I'm Ben Olson, content developer at Microsoft, and welcome to Ethics and Law in Analytics and Artificial Intelligence. This course is meant to give you the foundations you need in both ethics and law as it relates to the data space, to not only do your job well, and that's a given, but to take it to the next level in terms of making the impact that you want in the world and society at large, whether you're in a nonprofit or a for-profit. All the principles we're going to apply to actual data work in this course will come to bear. And with me to teach this course is Eva Lasbrigada and Nathan Colinero. And I'd love to have you two introduce yourselves and tell the audience why you care about this course.
Thank you, Ben.
Thank you.
I'm a law professor at Seattle University. I teach business law and data analytics and law. I'm also a partner in a firm called Digital Dignity. I've been investigating, thinking about, and writing about that intersection of human rights, entrepreneurship, and technology for many years. And I'm really excited to explore that in this course and share with the audience what law does apply to big data, and where there is not enough law or there's no law, what are we going to do about it? And considering the ethical frameworks that we might explore with Nathan as well.
Great, thank you.
And I'm Nathan. I'm also a professor at Seattle University teaching business ethics. And along with Eva, I'm co-founder of the consulting firm Digital Dignity. And this is a really important course for me. We understand principles of law and principles of ethics. We have them pretty well worked out. But there are some conversations that we need to have as we enter into this new space of data.
Thanks so much. And thank you for joining us, and we look forward to working with you through this course. Let's dive right in. In analytics and artificial intelligence, it's pretty evident that they're powerful. They're means of amazing digital transformation. We have things like almost instant communication between people who are speaking different languages, and self-driving cars coming to market, predictive healthcare. Almost every industry and vertical is being touched by this advancement in data and technology. But in some ways, it kind of begs the question of why ethics and law in relation to these powerful advancements. What does it bring to the table, and what are students going to learn in this module?
That's a great question. Actually, typically when there's innovation, law and ethics are chasing after the innovation. There's a tension. Law can never move as fast as business. Law can never move as fast as technology. And rather than wait for the law to eventually catch up, which it will, we can be prepared, right? So there's a couple things happening here. I mean, we're looking at law and ethics, the relationship between the two of them really are that the law is going to be a moral minimum. Ethics is always going to be a higher bar. And Nathan will be providing ethical frameworks in this module for us. I'm going to be providing legal frameworks. And the point of learning those is to prepare students to know what the law is, what law does exist, so that they can use it creatively and not be waiting for the hammer to fall necessarily.
Yeah, almost like a competitive advantage.
Yeah, it is a competitive advantage. And, we teach our students constantly that, we're not talking about law and ethics so that they can feel constrained. We're teaching principles of law and ethics so that they can use that creatively, right? Progressively, creatively, innovatively, and be prepared and ahead of the game, right? So they can be competitive, strategic, and also at the same time be doing good.
Yeah, that's actually a great point about getting out ahead of the technology. So that reminds me a lot. I mean, really what we're talking about now is design, okay? So it reminds me of two of the best thinkers working in the environmental sustainability space are McDonough and Braungart. They're more well known for their books, The Upcycle and Cradle to Cradle. But they have an earlier academic paper where they make the case that our ecological crisis that we have right now. I mean, think about how much of a pain it is that we're trying to go around cleaning up problems, right? And they argue that, back when the Industrial Revolution started, there was evidence that it wasn't designed for sustainability. The Industrial Revolution wasn't, because no one had any idea that humans could damage the environment. It was like the environment is this big, huge thing that could just eat up human activity. Now, it turns out that prediction or that assumption was quite wrong. But the point is that the environmental crisis that we have now is because the Industrial Revolution happened without anybody thinking about, do we need to think about sustainability? Because no one did. They just assumed that, we can just do what we want and Mother Nature will take care of the rest. I'm kind of thinking that we're at a similar point now within the digital space with big data. We could imagine a time in a few years, a decade, where we're trying to clean up little problems with legal and ethical principles. But it would just be so much more elegant, so much better if we just thought about it the right way from the beginning.
Thanks, Nathan. Thanks, Eva, for your perspectives. I think what you're saying is critical, and definitely why we're launching into this first module with foundations of ethics and law to get that competitive advantage of having those frameworks when we do this analytics or artificial intelligence work. So thank you, and let's dig in.
The age of big data will bring a socioeconomic revolution because over a very short period of time, big data will reorganize the way we live, work, and interact socially, much like the agrarian revolution and industrial revolution did. This revolution is inevitable because of the incomprehensible amount of data suddenly available about human activity and the things we use. The technology necessary to collect, store, process, and analyze this raw data in order to make it useful for gaining insights, data mining it's called, is quickly increasing in sophistication. Businesses, governments, and other organizations are scrambling to take advantage of these technological advancements. With due respect to King Solomon's great wisdom, his proclamation that there is nothing new under the sun is getting a run for its money. The data revolution is coming, and it will benefit a lot of people in a lot of ways. We are data optimists, which means, among other things, that we are excited to see the changes that big data will bring. Enormous industries, such as healthcare, transportation, and criminal justice, will become more intelligent, more efficient, and more accurate. Many needless harms of the past that were ultimately rooted in a lack of data will be eliminated. From an ethical perspective, this coming benefit is welcome. But, like all revolutions, this one will have both winners and losers. You don't need a crystal ball to see that while many will benefit, the data revolution will inflict harms in two ways. It will give bad people new ways to be bad, and it will also inflict harm in unintended and unforeseen ways. Considering this mix of benefits and harms, there are four possible responses to the data revolution. One response is a desire to return to a pre-digital age or to stop technological progress, but short of some severe global and permanent crisis, this is simply not realistic. The world is not going back to small data. A second response is unchecked optimism. Some people often embrace new technology simply because it is new and cool. But this is also a mistake. We believe that there will be coming harms, and to ignore these is irresponsible. A third response is to feel uneasy about the big data revolution, but accept it as inevitable. We all hear regular people voice this position when someone mentions how this or that new technology is a bit creepy, and then in the next sentence you find out they use it anyway. We prefer a fourth response, which is to accept the revolution as inevitable, but to believe the revolution can and should be designed. It might help to think of Kevin Kelly's use of the word inevitable in his 2016 book by the same name. Inevitability in this sense allows for the possibility that the specifics might be otherwise. For example, we might say that given that the human species is social, it was always inevitable that the digital world would eventually give us social media. But while social media itself is inevitable, it's not inevitable that Twitter, Facebook, and Instagram would be the biggest social media platforms, or that they would have developed the policies and procedures they did. That just happened. We believe strongly that while it is not possible or desirable to stop the big data revolution, it is our responsibility to consider the kinds of harm that the use of data can inflict. And once we have identified them, we must do what we can to design the revolution so that the predicted benefits of big data will come to complete fruition. It is thoughtful, considerate design of the revolution that is one of the biggest challenges of our generation. Just letting it happen is a recipe for disaster. How is such design possible? We believe that the two most important tools for designing this revolution are bodies of knowledge that have been with us for millennia, principles of law and principles of ethics. We hope that this course shows how these time-tested principles are relevant guides in this new human era. It may be tempting to think of data as alphanumeric digital expressions of some kind, but that's only one kind of data. Data are simply recorded facts, and they are neutral with regard to what counts as a fact and how those facts are recorded. One implication of this idea is that data have existed from the moment our ancient ancestors had the ability to record facts and found it useful to do so. Some very early examples of data creation could be a symbol etched on a cave wall, or scratchings on a tree indicating the number of necessary foot paces to a burial site. For most of this age, data recording would have been done by hand or by some related physical means. In the middle of the 19th century, a new kind of data became possible when scientists discovered different ways to record sound using analog technology. Recorded images have an even more complicated history, with even ancient societies using principles of light to record images. For our purposes, we might put these and other technologies together and call them the pre-digital age of data. In the last couple of decades, the term big data has been increasing in popularity. There are some who don't like the term because it's not technical. They might note that big is a relative concept, and so what counts as big today will not be big tomorrow. There are also attempts to define the term big data along the lines of the features and benefits of data. For example, you have probably heard of the so-called 5 V's of big data. But we don't need to get too technical to understand the most fundamental difference of this new age of data. It is right to call data big simply because there is so much of it. One estimate puts the amount of all existing data from the beginning of recorded history until 2003 at 5 billion gigabytes. That might sound like a big number, except the same study estimates that just a few years later, by 2011, the amount of data generated every 2 days was 5 billion gigabytes. Probably the best place to start the story of big data is the late 1940s, when the transistor was invented, which, for reasons far too technical to describe here, allowed us for the first time to record facts digitally, that is, as encoded in ones and zeros. This is the digital age. This is important in explaining this massive increase in data because non-digital data storage is remarkably inefficient. Yes, you can create data by writing down someone's name on a piece of paper, but that requires a lot of space and does not record a lot of data. Digital storage partly explains why data got so big. The other part of the equation has to do with who or what is recording the data. When a human being enters data into a database, there is a natural barrier to how much data can be recorded, simply because of the biological limits of human recording abilities. But now, data about you and me is recorded automatically by machines. To take an easy example, your smartphone records your location every second of the day, all the websites you visit, songs you listen to, texts you send, etc., etc. This means that you alone, even on your most unremarkable day, create a mind-numbing amount of data. Now, all this data is recorded in databases, but not by a human. No person is furiously updating your location in a database each time it changes. Rather, a machine records it all automatically. So what is important is that we have crossed two thresholds. The first in the ability to store data in ones and zeros, and the second in the advent of machines automatically recording that data. Crossing the first threshold took us into the digital age, and crossing the second threshold took us fully into the age of big data. In this video, we'll talk about ethics. We're going to talk about what it is and how it relates to data and creates this kind of new field called data ethics. And I think I know what you're doing right now. You're probably typing what is ethics or ethics definition into your search engine. If you want to do that, that's fine, you can. I just don't think it's going to be very useful because what's going to pop up are about 1 million results. Some of those definitions are going to be pretty good. Some of them are not quite as good. But the abstract definitions just end up being complicated and or hard to remember. So what I want to do is just make it as simple as possible instead of an abstract definition that, let's be honest, you're going to forget about anyway. Let's just talk about what it means to be an ethical person, what it means to have ethical concern. And that just means a concern with human well-being. So if you're an ethical person, you care about the well-being of people. It's as simple as that. So there is something complicated, or at least we can make it complicated if we want to. There is this concern. If you know anything about ethics, there's a lot of different theories and there's a lot of different principles, and some of them it takes a while to understand. And certainly, if we have to go back and compare and contrast them, that can get really messy. And in fact, if you really wanted, you could probably get in your car and drive to an ethics conference somewhere in the world, or ethics conferences are happening. And what's happening at these conferences are experts who spent their entire lives reading these complicated texts are arguing about the best ethical theories or how to interpret these principles. I don't think, if that's what it takes to be an ethical person, there's probably no hope for the rest of us, right? Because most of us just can't afford to spend our entire life going to ethics conferences and talking about ethics. So the good news is that the actual process of just engaging in ethical thinking, being an ethical person, is much simpler. Okay, so here's how this works. You've probably heard of specific ethical theories, utilitarianism, deontology, or maybe it's called Kantianism sometimes, contractarianism, there's virtue ethics. All these are ethical theories. What they have in common, now not all moral theories, there are some theories like cultural relative or divine command theory, you might have heard of those. They're not built on any human value. But really good moral theories, such as the ones I just mentioned, and there are a couple others, are built on the observation about a particular value, something that makes life go well for human beings, something that's central to human well-being. They take that value and then they build a complicated theory around it. And there comes out with lots of principles. And then we can get to the business of comparing and contrasting those principles and comparing and contrasting those ethical theories. And that's where it gets complicated. Now, if our job were to attempt to understand even the basics of those arguments and how they work, we would have a lot of work to do. And as I suggested, the experts are still busy disagreeing with each other about how this all works. And so maybe an infinite amount of work to do, which is just not going to work for us. So what I propose doing is let's leave the theories and principles where they are. Are theories and principles bad? Absolutely not. My job is to teach the theories and principles, and I like my job very much. I think there's definitely a role for it. But when we're talking about what it means to be an ethical person, what it means to think ethically, we don't need to understand the theories. We need to understand the values underlying those theories. And remember what I said about the values. Any good moral theory is built on an observation of a particular value. And other good news, or continuing the string of good news, there are really only 5 values. Now, that's my list. Someone else, another professional ethicist, might have a slightly longer, shorter list, but I count 5 values. Let's talk about those values. And unlike the theories and the principles that they come from, I think partly we already understand these values, but they are things that we can get in our minds and think about and constantly review. So there are 2 sets of values. The first set are values that are based on the well-being of others, well-being of other people. There are 3 as I count them. So one is, why should I care about another person? What makes another person or other people morally valuable? So one observation is that what makes people valuable is that they're capable of suffering. They can feel pain, physical, emotional. If there's other kinds of pain, that would all count, right? I should care about other people just because they can suffer. Because they suffer, it means I have to think about them before I act. Also, autonomy. Autonomy just means something like people are able to control their own actions, to make their own plans, to live life the way they want to. Now, obviously, there's going to be limits to that, but the fact that other people are autonomous, the fact that other people can control themselves and think about problems and do things the way they want to do them, already that means that I have to respect that about them. It would be wrong for me to use them because they already have their own agenda. Equality. That would be another reason that I should care about other people, because I'm not superior to them or inferior to them. They are equal to me. So when I act, I have to respect that equality. There's another set of values. These values are not strictly based on other people's well-being, although they are in the end. But in the first place, this is about my own well-being. This is about what makes life go well for me. So one of these values is character excellence, or virtue it's called in the ethics literature. This just means that part of being a good person, the kind of person I want to be, is having a certain kind of character. The other value here is trust. Trust is something that makes my life go well. When I'm in a high trust environment, many of the things that I want can happen, right? If there's no trust, or if you're in a society that doesn't have very much trust, or if you have the reputation of a liar and people don't trust you, your life's not going to go as well. So I believe that these things, and many ethicists do as well, count as ethics. So both the well-being of others and your own well-being. Okay, so to illustrate how these values work together, we're going to do a little thought experiment. This is a purposely absurd thought experiment. You will never, hopefully, actually ask yourself this. But let's say, for the sake of being extreme, you're asking yourself, should I torture an innocent person? Not like to find the secret bomb or something like that. Not even talking about that. I just mean like torturing someone for fun. Should I do that? That's what you're asking yourself. Well, I hope that you would say, no, that's the obvious answer. And there are a few reasons that you might come up with. And all these reasons are ultimately rooted in the values that we just talked about, right? Torturing another person would cause them suffering, and that's bad. Torturing another person would be not respecting their autonomy, and that's bad. Torturing another person would be treating them as inferior to you, and that's bad. Torturing another person would ruin my character. You can ask, some of the soldiers in the past, in past wars who've been forced to torture their prisoners. They talk about how that really affected their character. If I torture other people, that's going to destroy the trust in that relationship, certainly, and maybe social trust if it just becomes normal for people to randomly torture each other. Okay, so that's our thought experiment. Don't torture. It's not a good idea at all. Let's ask ourselves what we learned from that thought experiment. The first thing we learned is that engaging in ethical theory is not complicated. So remember, the complicated part is talking about and comparing and contrasting all those theories. But you didn't need me to walk you through that, whether you should torture other people. You already knew that, right? I just gave you some specific reasons based on values. So it's not complicated to engage in ethical reasoning. Now, maybe the best conclusions there are going to be cases that are more difficult, and that's okay. But just engaging in the process is not complicated. The second thing we learned is that if you're an ethical person, you appreciate all of those values. I mean, think about how absurd it would be if someone said, well, I really care about the suffering of other people. That's why I don't torture. But I don't care about their equality. I mean, that would be such a strange thing to hear, right? An ethical person, a person that's concerned with human well-being, is going to take all 5 of those values into consideration. The last thing we learned, and this is kind of implied in the thought experiment, that the reason you wanted to apply those values is because you cared about other people's well-being in the first place. There's nothing I can really do. I mean, if you don't care about human well-being, I don't know. There's no ethics that can really get you to care. But ethics, applying those values depending on you caring in the first place. So let's talk a minute about how this applies to data. Well, if ethics is the study of human well-being, data ethics, we get a nice tidy definition, is just the study of how data affects human well-being. And let me tell you, it affects human well-being in a lot of positive ways and a lot of negative ways. We can talk about this from a process side. Data is collected, stored, processed, visualized, used in decision-making. And it turns out that in each of those 5 steps, there's specific things to talk about how human well-being is affected either positively or negatively. We can also talk about this from the perspective of who is being affected. We can talk about individuals. We'll do that in Module 2. We can talk about groups and societies and citizens. That's what we're going to do in Mod 3. We can also talk about customers and employees and businesses. This is what we'll do in Mod 4. There's all these dimensions, all these groups that are affected in different ways by the use of data. Their well-being is affected, and that's what makes it ethical. Now, a previous video, we talked about how data is actually a very old thing. It just means recorded facts. So markings on a cave wall count as data. But now we're living in this age of big data. So whatever this data ethics thing was, that data ethics has existed as long as data has. Now, all those problems are still with it. But because data is big, there's more problems. And they're also sometimes more complicated. So in this course, we want to talk about some of those issues.
Law tells the story of civil society through rules that govern the rights and responsibilities of individuals, organizations, and governments. In a later video, we will examine sources of law, or where the law comes from. But for now, let's consider the role of law in society and its relationship with technology. The rules of law of a society reflect its values. For example, the European Union and its soon-to-be implemented GDPR reveals that it values individual privacy. The U.S. Constitution's First Amendment reveals that America values free speech. One of our first themes for the course is that law is territorial. It's confined to the territory of the place that created it. Like an old-school hardbound textbook, the law story is confined to the geographical boundaries of the nation that wrote it. This simple concept, territoriality, adds complexity for organizations that operate in more than one nation, because they must comply with new and sometimes conflicting legal obligations from one nation to another. It adds even more complexity when operations are computer-driven and internet transmitted. Law likes what is physical and present within boundaries of states, regions, and nations. It likes less what is intangible, such as that which is digital. So the relationship between law and technology starts off rocky. Intensifying this misalignment is the fact that technology evolves at a rapid pace. Law, on the other hand, moves as slow as a snail. It is always catching up to technology. In June of this year, Brad Smith, president and chief legal counsel of Microsoft, noted this relationship in a talk referencing a U.S. law, the Electronic Communications Privacy Act, or the ECPA. This law was passed by Congress in 1986 during the age of police wiretapping. This was also the age of the historical relic, the phone booth. In an ongoing struggle, courts have considered the privacy protections of the ECPA and evolving needs of law enforcement to access communications of non-U.S. persons stored overseas by corporations. It's a misfit, but it's a great example of the struggle to take antiquated law and apply it to modern technologies. This leads to our second theme, the strained relationship between law, data analytics, and AI. Like law, data tells stories. The issue is that there is little, if any, law to regulate how the data is collected, managed, shared, and used for the story. We will see many examples in our course of how some extraordinarily brilliant researchers are thinking about how existing law may apply to rapidly evolving technology, or what new laws we need to set right this relationship. Our last course theme to consider at the outset is the legal tension that exists in this space with respect to human rights and organizational rights. There are many organizational players to consider that engage human data in different contexts, creating legal questions almost at every turn. For example, does a social media organization that has access to a person's shared information have the right to define the identity of that person? Who controls human autonomy? Human beings or data owners? With respect to issues of bias, if a person believes he was discriminated against as a result of algorithmic failure, will the law demand transparency of that algorithm to prevent future bias? Or will the organization's intellectual property rights in the algorithm win? There are a variety of types of law that are relevant in data analytics and AI. In the U.S., these include privacy law, consumer protection, employment discrimination, negligence, due process, and intellectual property, to name some. These types of law can be classified in and across 3 basic sources of U.S. law. Classifying law by sources helps us understand the big picture of law as it relates here to big data, and also to better understand how and why the law applies to issues of technology. The 3 principal sources of U.S. law are common law, or judge-made law, statutory law, and constitutional law. Common law is law created by courts. In the U.S. and other former British colonies, judges have authority to actually create rules of law that determine individual and organizational rights and responsibilities. Certain types of law are traditionally common law. For example, negligence law, which is about our responsibility to be careful in everything we do, from driving a car to hiring employees to managing data, is sourced in common law. If I want to know the rules of negligence, I will research and review court decisions. Statutory law, by contrast, is law created by representative bodies such as the U.S. Congress. Whereas courts create law in response to cases brought before them, representative bodies proactively create law that regulate individual and organizational behavior. For example, Congress passed the Genetic Information Non-Discrimination Act, otherwise known as GINA, to regulate how employers and insurance companies can, if at all, access our genetic information for purposes of making decisions about whether we're employable or whether we're insurable. Constitutional law, the last source, gives the government the authority to act and restricts that authority to ensure that the branches don't overstep their bounds or infringe unnecessarily on individual rights, such as rights to fairness and equality. When the government takes actions with respect to data, it is likely the Constitution will have a role in restricting what the government can and can't do. Now, some types of law are sourced in all three sources. Privacy, for example, is sourced in common law and what we call privacy torts. It's sourced in statutory law, such as GINA and other legislation that protects financial, health, and student privacy. And it is sourced in the U.S. Constitution's amendments. Now, remember, this summary is just about sources of U.S. law. If an organization is operating in another country, that organization is subject to the law of that nation, its variety, and its sources of law. Recall that one of our principal themes is that law is grounded in territory. It is territorial. It's determined by geographical boundaries. So finally, we want to look at what international law is and how that relates to these three sources of U.S. law we've been talking about. International law, or global law, is really unique, and it's relevant in very specific contexts, such as international trade. For our purposes, there is human rights law that is international, and that informs us about what individual civil and political rights are, which ones are protected, which ones are valued. These rights are also partly enshrined in our U.S. Constitution. What's common to all of them, the rights in the U.S. Constitution and the rights in international human rights law, is that the cornerstone of all of these rights is human dignity. There's the United Nations Declaration of Human Rights, which was signed after World War II, and several related treaties. However, these documents are not per se binding, and to the extent that they are binding, they're binding on governments, not private organizational parties. One of the objectives for our course is to move beyond learning about analytics and artificial intelligence to applying legal analysis to issues that arise for you as a data professional in this field. This course is no substitute for legal counsel, but you can learn the foundations of legal analysis, which should be really helpful for identifying potential legal problems and making strategic decisions that are lawful. What's also revealed in applying legal analysis is the lack of law that exists and that is on point for these rapidly evolving technologies. In those cases, the ethical frameworks provided and explained by Professor Colanero will become even more compelling. The legal analysis framework we will be using in this course has 4 parts: issue, rule, application, and conclusion. We refer to this framework as IRAC. It is a traditional method for analyzing legal problems that arise in any context. It's also just a time-tested, straightforward problem-solving tool that can be applied to other disciplines to help us work logically from issue identification to action. I will explain the parts of the framework and provide an example of how it is applied using the Target teen pregnancy case from 2012, which is now somewhat famous for its creepiness factor. Almost every major retailer, from grocery chains to investment banks to the U.S. Postal Service, has a predictive analytics department devoted to understanding not just consumer shopping habits, but also their personal habits, so as to more efficiently market to them. The story that got national attention in the U.S. began when an irritated father at a Target in Minneapolis complained to the store manager about sending his daughter a sale booklet for baby clothes, cribs, and diapers, even though she was still in high school. Target apologized and learned some hard marketing lessons in the process, but the reality was that the daughter was, in fact, pregnant. Target knew about it before the mom and dad did. Let's look at this scenario through our legal lens using IRAC. The first component, the issue, is defined as a legal problem that is inherent in the situation. Spotting a legal issue or issues in a factual scenario is always our starting point. Here, the issue might be stated as whether Target infringed on the teenager's rights by using data about her purchasing behavior to identify her as pregnant and to then market to her appropriate consumer products. Next is the rule. What, if any, rules are relevant to this situation? Here, the overall situation is highly personal, even intimate. Does that mean that there is a possible privacy right violation? If so, because Target is an organization versus a part of the government subject to the Constitution, we would start by considering common law privacy torts to see if they are relevant. We will learn more about these privacy torts in later modules. We might also research if there are any statutes on point that protect her privacy interests here. Unfortunately for this young teen, although the algorithm revealed a highly personal, even intimate fact about her, there are no privacy laws to protect her. The data used was provided by her purchasing behavior. Target used internal customer information and externally publicly available data. In applying the facts here to the existing rules of privacy, there is no breach. Thus, we can conclude that Target behaved lawfully. That's the conclusion. However, the fact that Target could legally learn something private about its customers doesn't mean that it was ethically appropriate. Just because you can do it doesn't mean that you should.
There's an old saying that there are lies, damned lies, and statistics. The idea is that lying with statistics is actually even easier than lying with regular words, because when many people see numbers, charts, and graphs, their brains just tend to shut down, and they accept what they see. This view was popularized with the classic 1954 book called How to Lie with Statistics, which has been a bestseller ever since. Many of us assume that numbers speak for themselves, and that they give us the unfiltered, objective truth. But that is a seriously mistaken assumption. The fact is, it is really easy to misunderstand data, even if you're doing your best to be honest. And of course, if your goal is to manipulate someone, you can really do a lot of mischief. This is true of data of any kind, small or big, especially when it comes to collection, visualization, and interpretation of its meaning. These mistakes happen, respectively, when data is derived from a sample that is not properly random, that's a collection problem, or when a graph is presented with misleading proportions, that's a visualization problem, or when the unit of analysis is overlooked, that's an interpretation problem. We must emphasize that with big data, these are still important worries, and actually, most of them are more complicated now. We will talk about some of them in Module 3 of this course. However, a new kind of subjectivity in data is now possible, and that is because data can now be processed by algorithms. There are actually two problems, because before data can be processed, it must be pre-processed or cleaned. We will talk about the issues with processing data in Module 3, since that can lead to systematic bias in society. Data scientists often refer to cleaning data as ETL, extraction, transformation, and loading. This is because any dataset you come across will almost certainly not be able to be uploaded to a program to be processed by an algorithm just the way it is. Many data scientists will actually tell you that this is the most time-consuming part of their job. The problem is that it is extremely common for a large dataset to have inconsistencies, duplicates, corrupted data, missing data, outliers, and entry errors. The data scientist must make many decisions about how to deal with these problems, and they will create changes. And it is an open question about whether these changes make important changes in the results. In The Promise and Peril of Big Data, David Bollier defines data cleaning as the process of deciding which attributes and variables matter and which can be ignored, and quotes tech CEO Jesper Anderson that cleaning removes the objectivity from the data itself because it is a very opinionated process of deciding what variables matter. The tendency to turn your brain off when confronted with big data conclusions is exactly the opposite of what you should do. When big data offers you answers, it is time to think critically. Two researchers at the University of Washington have focused on the problem of lying with big data and advise asking as many questions as possible before accepting conclusions from big data, such as, who's telling you this? How does it advance their interests? What were the methods used to arrive at the end result? We will link you to some of their work in the further reading section. Also, in his book, Naked Statistics, Charles Whelan gives the same sort of advice, but directed toward the statisticians who present the findings. He cautions that statistical analysis is not like math, which yields a correct answer, but more like detective work. This requires constant, honest, and humble communication among the detectives, and even the best may still end up disagreeing about what the results mean. None of this is to say that big data is a bad way to go. In fact, it's often the best way we have to gain important insights. But both producers and consumers of big data must use caution.
So you heard from Nathan about ethical data practice as it relates to moral maximums, what one ought to do, even if there are no legal repercussions. And from Eva, you heard about the legal side of things, where we have restrictions, it's perhaps a moral minimum, provides sort of the guardrails for data practice. But what should a practitioner actually look at maybe day to day to inspire her or him to do ethical data work? And I look to other disciplines that draw inspiration for this, and healthcare comes to mind. There's this old guy named Hippocrates who lived way back when and created what's called the Hippocratic Oath for healthcare practitioners. And what's fun is, it's sort of inspiring. It's declarative, like I swear by this or that to do these things well. But it's actually used in modern healthcare. Oftentimes it'll be framed or referenced, and that's mainly to provide some sort of ethical guideline for healthcare work. And in data, we don't really have a centralized version of this, but there are examples out in the wild. Perhaps maybe one is UN's 1985 Declaration for Statisticians, and it's extensive. It's focused on best practices as it relates to that subdiscipline. It's extremely long and thorough and great. I doubt that a lot of data practitioners have read it, so we're going to reference it in the further notes. But please take a look at that if you'd like. It is a good example, but it's a little dated. Another one would be Certified Analytics Professionals Code of Conduct, and this one's fun. It's it is focused on the obligation of others and not a lot about what I as a data practitioner am going to do. Perhaps maybe missing that fun declarative aspect of I swear by this or that. So I'm going to take another crack at this and give you what I call an updated data oath, and it's perhaps what I would say if I were doing data work to do data ethically and do it well. So, you can say it with me, you can put it on your wall. So I, as a data practitioner, will promote the well-being of others and myself. That's harkening back to Nathan's work on the ethics stuff. We'll strive to do no harm with data, perhaps to the legal side, through professional application of analytical techniques, number one. I do my job well. I know how to interpret p-values and correlation and not bump into causation. I know how to do data visualization well, proper cleaning and transforming and analysis of data sets. That's all part and parcel of doing analytics well. And of course, fundamental to our job. And maybe next would be humility in analytic claims. So that's maybe a step further with the correlation stuff, moving into predictive analytics, moving into more of these inferences that you make. Perhaps you give some confidence interval and range in what you're claiming. You speak with as much honesty and humility as you can when it comes to these analytic products. And also, hopefully what this course is prepping you to do is to anticipate legal and regulatory needs. And that goes without saying. And almost in transparency and computation documentation is also something that's going to reoccur throughout the modules in this course, where we want to share what's happening in the data processing and in the output space so that we can avoid things like bias and protect privacy and all those things that we're going to investigate in the next modules. And lastly, I'd say fidelity to this oath beyond the bottom line. And that's maybe in ethics, we call it a supererogatory claim to promote people and encourage them to do good with their data work beyond corporate bottom lines or individual success for the good of society and the world at large. Thank you.
We're going to do our first IRAC exercise now. IRAC, as you recall, is our legal analysis tool to understand how to move from identifying a legal issue to reaching a conclusion and a decision about how to take action. For this first one, we're actually going to use an existing case so that we can learn about the component parts, the issue, rule, application, and conclusion, and also just more easily understand how this particular story and this particular case relates back to our three themes for the course, which are that law is territorial, that there's a tension between law and technology, and finally, that there is a strained relationship between organizational and human rights in instances of law and technology. So all of these cases start with this story. And again, this case is about a real case that concerned Microsoft. In this story, Microsoft stores data about its customers both in the United States and overseas. The information is stored in email communications. The U.S. government was issuing a warrant under a U.S. law called the Stored Communications Act because it was in an investigation about a particular individual, and it wanted access to email communications that Microsoft had in its possession, both in the United States and overseas, in this case, overseas in Ireland. So the U.S. government issued a warrant, tried to get the information. Microsoft turned over the information within the territory of the United States, and that means within the territorial reach because they were on servers and in data centers in the U.S. But with respect to the information held in Ireland, it refused to turn over the information, at which point the government issued this warrant and actually held them in contempt. So coming out of this story, the issue is, in this case, whether that law, the Stored Communication Act, allows the U.S. government to obtain customer information stored in email from computer service providers like Microsoft when the information is stored on servers and in data centers that are outside of the physical territory of the United States. Remember, law is territorial, so we're really concerned with where the physical boundaries are for countries and nation states and governments. The rules here, once we identify what the legal question is, we look to see what the rules are. And again, I'm giving you the rules in this IRAC so that you can start to learn how the process works. The first rule is that the Stored Communication Act, which is a part of something called the Electronic Communications Privacy Act, does actually protect consumer privacy, consumer private communications, electronic communications. That's what the intention of the ECPA is. However, there's exceptions to everything, and the Stored Communications Act does allow the U.S. government to access electronic communications of individuals pursuant to its surveillance and law enforcement activities. The second rule that's applicable here is a presumption, and there's a presumption in U.S. law against what we call extraterritorial application of law. What does that mean? It means that there is a presumption against any government reaching outside of its physical boundaries and trying to control what happens outside of those physical boundaries. So when the government, like the U.S. government, wants to try to control something outside of the United States, we say that that's an extraterritorial application or reach. And there's a presumption against that. The Supreme Court recently, in this Morrison decision, which is cited for you here, has said that there is a presumption against the extraterritorial application of U.S. law. So in the application component, what we do is we take the rules and we apply them to the story of the case. And my question for you here would be, how would you apply those two rules on the previous slide to the facts of this particular case where Microsoft is contending that it is not responsible to turn over customer information held overseas? Finally, the conclusion is actually, we know what the conclusion is in this case because there was a decision. The Second Circuit Court of Appeals, which is an appellate court in the U.S. federal court system, actually held for Microsoft. They found for Microsoft. Microsoft won this case. And the court said that Section 2703 of the Stored Communications Act was not intended to extend beyond the reach of the United States. Yes, it extends in the United States, where the territorial jurisdiction is, but it does not extend beyond. There's a presumption against that. And Microsoft was actually within its rights to protect consumer privacy and refuse to provide the information to the U.S. authorities. Now, interestingly, you see here that that relationship between an organizational rights and individual rights is in alignment. Microsoft was, in fact, protecting its customers' privacy. And so the rights or the concerns of the organization, Microsoft, were in alignment with the customer in this case.
Congratulations on getting this far in Module 1. Before you take your final assessment for this first module, we just have one more important thing to do, and that is we're going to get our lab started. Each module is going to have a lab at the end of it, and we're going to use the same data set or a very similar data set. There's a couple versions of this data set we'll be using. So if you look at your instructions, they tell you that you should download a set of documents from GitHub, and you're going to have to download them as a zip folder. So I've already done that. You can see this is what you should be looking at when you go to GitHub. You're going to have to create an account. It's free. So there's a bunch of files associated with this project. So what you're going to do is go to the clone or download, and then download the zip, and of course then unzip it. And I would like you to pull up the CSV file that it says comma scores 2 years violent. And let's get to work on that. Okay, so regarding this project, you're going to have several specific ethical and legal questions to answer in the next few modules about it. But right now, we just want to figure out what this data is, what it means. Another way to think about that is we're getting the context. This is something that you do no matter what when you're data science. You always have to get the context first and then answer the specific questions. For our concerns today, we're also getting the ethical context. But let's start with the most general stuff, just exploring the data. So this data set is about recidivism, which is how likely it is that someone is going to reoffend. So once someone's been in jail, we wonder, are they going to go to jail again? Or are they going to commit another crime? This is a very fundamental problem of law enforcement because they have to make decisions about how long to keep somebody. Should we keep them in jail for a long time? Do they not deserve to go to jail? So this data set is regarding that general problem. So we got to figure out what's going on with this. So you can see there's 3 steps here, and each step is going to have a few questions attached to it. So let's just start with some really, really basic things about exploring the data. So here's a question. How many observations are in this table? So in data science, an observation basically corresponds to a row. So in this data set and most data sets that you'll ever encounter, each new time an observation is made, there's a new row created. All right, so here we observed a new person, we made some observations about them, and that's a new row. So the question is, how many observations are in this data set? So here's one way you can do it. The easiest way in Excel is just by clicking on the column, and then down here it'll tell you it's 4,744, which is extremely small. This doesn't really count as big data, but that's okay. We're just practicing here. Now, one thing, might be some empty boxes. So you might want to go to a column that is the least likely to have empty boxes. So the ID column, it seems very unlikely that someone would have been counted as an observation without having an ID attached to them. So I'm going to click on that. Yep, still 4,744. Maybe just click on one other. Yep. But as you can see, some of the columns, so like this one, I can already tell that it has some missing data. So if I click on this, I'm going to get 4,476. Again, this is that's inconsequential. But if you're dealing with a huge data set and you start looking at a column that says you have 4 million data points when actually you have 10 million data points, that can really throw things off for you. So that's the answer to that first question. The number of observations, we've got 4,700 and some. How many variables? So a variable corresponds here to a column. And let's see, we can do this easily with Excel because they do the ABCD thing. So we've got to Z, then we've got to Z again, and then we've got 2 extra ones. So 26 plus 26, 52, 53, 54 variables. Some data scientists call them attributes. There's a small technical difference, but it doesn't matter too much. And if you want to be precise, you could say that, well, this is the person. Right? Attributes are like characteristics about the thing that you're examining, the thing that you're observing. So you could say, well, this is the person. This is their name broken into 2 pieces. So really, it's like we have 51 variables regarding this person. All right, which variables appear to be from collected data? So here's what I mean. There's a bunch of variables here, and as we're getting the context, I just want you to think about which of these pieces of data were just collected. So I would think name is collected, obviously. The age, that's going to be just collected data. They just get that from somebody. Gender. So look, this is really basic stuff, but if you're getting frustrated with how basic this is, getting the context is extremely important. It's going to make it much more likely that when it comes to the detailed questions later that you're going to be successful. Okay, now variables that appear to be assigned by the user. So these aren't collected from the world. These are things that the user just says, okay, now we're going to stick you with this. So the ID appears to be assigned by the user. I'm looking through here. Are there any other ones? There might be a couple other ones, but that's just what I mean there by assigned by the user. Which variables appear to be generated by algorithms? So this system fed an algorithm data and it spit out a result, and that created a new variable. So this is predicting recidivism, and I'm looking through here. This column says risk of recidivism. It appears that it says that for everybody. And then it gives a person a score. And then it breaks out that score by, looks like low, medium, high. Okay, so I would say that these 2 rows would be generated by an algorithm. Again, this is all just helping us understand what we have in front of us. Can any variables be safely eliminated? Now, you want to be careful here because sometimes a variable seems completely unnecessary, and then later on it turns out to be helpful. So you don't want to just go through and just start deleting stuff. But as a matter of fact, so I already mentioned that we already observed that there's less than 5,000 instances here. So this is, it doesn't matter too much in this case. But if you have a data set that has millions of observations and one of the variables is really text heavy, like if it has a description of something, that's going to really slow down the processing speed. So for practice here, let's go ahead and see if there's anything that can be safely eliminated. Now, I'm a little bit suspicious of what's going on in BA and BB because if you look, the column name is the same, 2-year recid. In itself, that doesn't tell us everything we need to know because there's lots of entry errors. People could have meant to type 3-year and it autocorrected or something, but I am suspicious, especially as you look down here, it appears to be basically the same numbers. So what we're going to do is run a correlation. We're going to use Excel formula, correlation. We're going to see how closely these columns are correlated. A 1 will tell us that they're perfectly correlated. That is to say, they're the same. -1 means they're perfectly negatively correlated, and 0 means they have nothing to do with each other. So if we get a number close to 1, I'm just going to get rid of one of them to save space for processing speed. So let's go to formulas, and we're going to need a statistical formula. And a correlation, just the first 6 letters of it there. And they're going to ask us which arrays we want to correlate here. So we want BA, and we want to correlate that. We want to check the correlation it has with BB. So let's see what we have. The correlation is 1, which means they're perfectly correlated. So for whatever reason, some data scientist accidentally cut and pasted. I don't know what happened exactly, but I do know that column BB tells us exactly nothing that column BA doesn't. So let's go ahead and get rid of that one. We're going to find the variable decile score and make that our column. Okay. Now it's not populated with data yet because we want to make decile score a value also. And this is something that you might want to review, but I don't want them to display as just raw numbers. I want them to be percentages of column totals. Okay, so you always have 100% of each column. But what this is going to tell you is that by race, who was predicted as likely to reoffend. So 10, remember, that's the one where they're like, we're really sure this person's going to reoffend. And if you look, 3/4 of the people that they were sure were going to reoffend are African American, versus Caucasians only 16%. Whereas, and I don't know what this -1 business is. I don't know if somebody meant to do 0 or if there is a -1. I don't know what that means. We have to figure that out later. But the Caucasians get all of that. And 1, which means a very low risk of recidivism, Caucasians are about half of the 1s. So we can kind of convince ourselves of this further with a little table. So let's go ahead and put this into a table. Make it a little easier to read. That one. Okay, it's kind of busy here. So let's first of all enlarge it. Second of all, now we might want to include some of these other things later, but for now, let's just go ahead and ask it to tell us about only African American and Caucasian. Okay, so if you look at the data, the blue means -1, and if we remember, everybody that was -1 was a Caucasian. Now, if you look at the trends in the data, you can see this really nicely with the graph. You see that as they get more and more suspicious that you're going to reoffend, the percentage of people that are African American that they're suspicious of grows, the percentage. And the Caucasian percentage seems to be shrinking as we go down. So when we get to pretty sure we're going to reoffend, right, you remember the statistic, African Americans very high, Caucasians very low. So those are some of the things that we're going to be thinking about, that we should be thinking about in answer to this question. Is there a significant discrepancy between the recidivism predicted of white defendants and other races? It appears that the answer is yes. Now, an important note, at this point, you are just exploring the correlations, the relationships between the data, the factual relationships. You're already tempted, I can pretty much guarantee you're already tempted to make some conclusions about this data. You might say, aha, I knew this algorithm was racist. We can't say that yet. We don't have enough information. There's a lot of detective work that we still have yet to do. All we've observed is that there's some differential treatment. There might be some reasons for that aren't bad reasons, right? We don't know that yet, okay? So all we can say is that these data have this relationship. We know that for a fact. We don't know why the data have that relationship. That's for a different time. All right, let's move on to the second question. Is there a strong relationship between prior arrests and the prediction of recidivism? And hopefully there would be, or at least I assume there would be, right? If someone's been arrested a bunch of times, I would assume that their chance of recidivism, if they've broken the law 50 times, it's probably pretty likely they're going to break it 51 times, right? But let's just make sure. Let's just make sure we're thinking correctly here. So we're going to go ahead and go back to the data and create another pivot table. And we will ask it to include all the data in a new worksheet. Okay, so in this worksheet, I think it would be nice if we had the score text as our row. Because if you go back to the set here, the score text is the one that's if the recidivism is low, medium, or high. So I kind of like that as the row. There's no rules here. You just have to play around with the data until you find something that makes sense. So let's go to score text. Okay, score text is a row. So that's what we wanted, high, low, medium. Now, for some reason, I would think that low would be under medium, but that's not the way this data is displayed. It's only 3 rows, so I guess it's not such a big deal. And for a value, we want to do the count of priors. So here is prior count. I don't know why that's given a 2. It's a mystery for a different time. And what I'd like to display is not the sum, but the average. So let's see what our data is telling us. Okay, so this is in line with our prediction. So you can see here that if someone has 6 prior offenses, what this algorithm says, and this isn't saying anything that's different than human intuition, is that they're more likely to offend 7 times, an additional time. Whereas if they've only been arrested 1.5 times, their chance of recidivism is much lower. So this is in line with our predictions. And you remember the medium and low has been switched, so it would be like 6, almost 4, and then 1.5, which makes sense. So that concludes Module 1. There's going to be some questions in the assessment that are similar to this, not these exact questions, but if this made sense to you, you shouldn't have very much trouble with those questions. So thank you.
Data isn't just about the bits and bytes. It can be really personal. It can be about you and about you in society at large. And what Eva and Nathan and I are going to talk about is this intersection of individuals, data, and society. So Nathan, could you tell us a little bit more about what this is going to entail?
Yeah, I think the conversation has to start around the topic of bias, because bias obviously affects individuals, but it's also a societal question at the same time, because we have to ask ourselves what kind of society we want to be. And predictive algorithms that predict your future behavior. They take large amounts of aggregated data about you that's actually been collected and then use statistical models to predict what's going to happen in the future. So as we now know from the lab in Mod 1, we're looking at recidivism. There are algorithms out there that predict, are you likely to commit a crime again? Does that mean we should hold you in jail longer? So those type of algorithms are often sold as, this is great because we're going to remove the human bias from these situations. There's all these studies about how judges and juries, et cetera, are biased, and so we can just get the bias out. But I think the most fundamental thing to understand about this is that we haven't solved the problem of bias. That's the wrong way to think about it. We have a new problem of bias, which isn't to say it's a worse problem. It might turn out to be easier to solve than the human bias problem, because that's a pretty persistent problem. But we have to start thinking in terms of, okay, now we got a new bias problem on our hands. And so that's a challenge. We have to confront it.
Great. Thank you. And Eva, how about you?
I think that this module is really going to help us identify the relationship between privacy and identity. So Nathan's talking about using this data. The data is largely private. It's personal to us. It identifies us. And there are zones of privacy that include questions of autonomy and self-determination. So we're going to be exploring the ways in which this bias is actually also taking away our right to fundamentally define ourselves. Right? And this is a fundamental right in international law and human rights law, in U.S. constitutional law, but recognizing that there is a relationship between the two things and recognizing the importance of not turning over to data science, data analytics, and artificial intelligence our fundamental right to define ourselves and create our own lives.
Brilliant. Thank you. Yeah, really important stuff, and we look forward to digging in. Thank you.
There will obviously be any number of differences between human bias and machine bias. And in this course, we are, of course, concerned with the bias of machines. But you may be surprised about how large the similarities are and how many they are. So let's begin with a basic distinction in human bias, and then we will use that to help us think about the problem of machine bias. When we speak of human bias, we are either talking about conscious bias or unconscious bias. And a quick programming note, many of you have heard the terms explicit and implicit in describing bias, and I mean the same thing with this distinction, but the terms conscious and unconscious are more descriptive, and so I'll use those terms instead. A conscious bias is simply one you are aware of. For example, you may be a male hiring manager and are convinced that women are less good employees, and so you disadvantage them in the hiring process. On the other hand, an unconscious bias is still a real bias, but by definition, you are unaware that you have it. In fact, you might very strongly and sincerely insist that you are not biased. But if the bias is subconscious, it could still be affecting your decision-making, and you might never realize it. We are here not thinking about the machine equivalent of conscious bias. That would be, to use our earlier example, if a male data scientist intentionally designs a hiring algorithm that disadvantages female candidates. It goes without saying that this is extremely unethical and certainly illegal, and so must be rooted out. But this is not the present concern. We are worried about the machine equivalent of human subconscious bias, the kind that slips into our mind over time through our experiences, but by definition, we are not aware of how it affects our assumptions and perceptions of other people. There is indeed a machine equivalent of this kind of bias, because bias can easily enter data processing without us noticing it in two ways. First, machines learn their decision rules from the data that we give it. It first identifies patterns in the data and then infers decision-making procedures in accordance with those patterns. Now, those patterns are probably quite accurate, but because machines are really good at their jobs. But if the machine learns from data that was itself the product of bias, whatever historical biases existed are now in the subconscious of the machine, so to speak. And this is not some hypothetical future concern. In the previous video, Eva gave some examples of how bias exists in the collection process. This is simply a version of the age-old garbage in, garbage out principle. If you feed the machine biased data, what do you think it's going to learn? In human terms, this is like sending a child to school that uses biased textbooks, or introduces them to movies or language that shows racial bias. What do you think the child's going to learn? In the previous video, we looked at one way that bias can enter the subconscious of machines, if you will, and that was through historically biased data. Now, this is true on a second level. Not only are machines bound to learn bias by biased historical data, but they may also develop bias by paying attention to the irrelevant data. In Module 3, we will name this as the problem of irrelevant proxies and examine the issue in more detail. For now, let's think about how an algorithm is created. Well, it necessarily needs inputted data, and as we saw in the Module 1 lab, you can call these variables. But of course, a machine algorithm does not use all the variables that ever were or could be collected. It only uses the variables that we decide to feed it, which is a step of the process, sometimes called feature selection. And remember, the ones who decide which features to select are human beings, the same as you and me, with all of our human temptation and biases. So if you tell the machine to incorporate the data relating to zip code, it will. But if zip code turns out to be a proxy for race, as it often is, you have just selected a feature that is going to make the machine's decision-making process more biased, and perhaps even just racist. It makes no difference that you intentionally introduced race or not. The disparate impact is the same. And it is important to note that the problem of feature selection and the problem of biased data introduces biased machines in ways that are often invisible. And when the biases are invisible, they have the potential to be much more harmful in exactly the same way that unconscious bias of humans can be. We all agree that conscious bias is bad, but at least it's more likely to be easy to spot. And it's much easier to fight an enemy that can be seen. If this makes you disappointed, that's an understandable response, because sometimes AI systems, such as predictive algorithms, are sold specifically on the promise that they will remove human bias from the decision-making process. A perfect example is the recidivism algorithm that we were working on in the labs at the end of each module. Inevitably, you will hear someone say something like, "See how great this predictive algorithm is. Now we don't have to worry about a jury or lawyers or a judge with bias in their hearts. An objective machine will do the job for us." And while it's certainly true that algorithms don't have the same temptations as humans, it is very important to realize that we have not solved the problem of bias. A much better way to think about this is that we have substituted one kind of bias problem for another. And even when or if it turns out that machines are less biased, or even when and if it turns out to be true that it is easier to fix machine bias than human bias, the fight against bias must continue. It just has a new level of complexity.
Kay Crawford, principal researcher with Microsoft Research, has stated that we are living right now in a great social experiment where the volume of data being accumulated about us is increasing to proportions beyond comprehension and awareness. Data sets are created, correlations are identified, and conclusions are made. Ms. Crawford is concerned with what she calls big data fundamentalism, or the belief that the conclusions made concerning data are objective truth. However, it's not obvious how all this data is being accumulated, managed, and shared about us. There's no transparency, meaning we are not able to see how the data is collected and used. Facebook can determine based on our likes what our race is, our sexual orientation, and possibly our addictions. But we are not aware how that information is cooked or who it is being shared with. There's a risk of bias against us based on a fundamentalist belief that data is truth. Based on data, we might be denied a loan or admission to a university. But we wouldn't know why because the decision is made by an algorithm or some form of artificial intelligence. So the initial premise here is that we have to get clear that we don't know what data is being collected and how it is being used, for good or for bad. This is an issue of transparency, which we will continue to revisit in this course. Also, we don't know who is being included in the data gathered and who is being excluded, and what harms might accrue to those left out of the big data revolution. Ms. Crawford uses the story of data collected during Hurricane Sandy to make a persuasive point that the data collected from consolidated tweets in Manhattan did not reveal the objective truth of how people experienced the hurricane, mostly because masses of people in the heart of the hurricane were excluded. Their data was not part of the set because they were not nearly as connected to the internet and social media as those in Manhattan. What we're talking about here is the bias that is created by virtue of the fact that we are not equally connected to technology. The truth that is established by data, therefore, is really only the truth of those included in the data. Attorney Jonas Lerman distinguishes between those included and those excluded by giving us examples of two hypothetical people living in the United States. Person A is a 30-year-old white-collar resident of Manhattan. She has a smartphone, a Gmail account, Netflix, Spotify. She's a Facebook user who dates through Tinder and OkCupid. She has a GPS in her car and an easy pass for tolls. Person B is a 40-year-old resident of Camden, New Jersey, one of America's poorest cities. He is underemployed, working part-time in a restaurant, paid cash under the table. He has no cell phone, no computer, no cable. He rarely travels and has no passport, no car, or GPS. He uses the internet at the library, and he rides the bus. Lerman's concern is with person B as a representative of all people excluded from the big data revolution. Those with a light or non-existent data footprint may experience, 1, tangible economic detriments because businesses will undervalue their preferences, and 2, possible exclusion from civil and political life because they're just not counted or considered. In legal terms, what we're talking about here are principles of fairness and equality. The Equal Protection Doctrine in the United States requires that we are all treated equally under the law. When we're treated differently on the basis of our race, ethnicity, or gender, there's a violation of our rights to equal treatment. Lerman points out that Equal Protection Doctrine, however, does not protect us when we're treated differently on the basis of our economic worth or how often we connect to the internet. And it does not protect us from actions taken by private organizations like corporations. It only protects us when the government treats us differently on the basis of our status in a protected class, such as race, ethnicity, and gender. If Equal Protection Doctrine does not protect those excluded, what law does? For that matter, what law or law protects those included, person A and those she represents, from organizations making determinations about individual identity, preferences, abilities, and the like? This is a question for us to explore throughout this module and this course. The Executive Office of President Barack Obama issued a report in 2016 which identifies the opportunities and challenges of big data, the law that protects civil rights and protects against discrimination, and also some best practices for organizations in the data industry. This report really highlights two of the course themes we identified in Mod 1, the tension between law and technology, and the tension between individual rights and organizational rights. In this video, I will share some challenges and highlight some principles of law that are relevant. In later videos, we will look at how these challenges and laws show up in four distinct areas: consumer rights, employee rights, student rights, and criminal justice. And finally, in a separate video, we will review the best practices suggested by the U.S. government to alleviate and eliminate bias. The White House Big Data Report identifies two challenges to promoting fairness and overcoming bias. One, the challenge related to the data inputs themselves that are used in algorithms, and two, the design of the algorithm systems. For the first challenge, the concern is related to our earlier discussion of inclusion-exclusion. The decision to use certain inputs and not others in an algorithm can in fact result in discrimination. For example, in an algorithm designed to determine the fastest route between points A and B, the architect of the system might include information about roads, but not bike routes or public transportation. This negatively impacts those who do not own a vehicle. Similarly, where the data inputs do not reflect accurately a population, there can be conclusions made that favor certain groups over others. For example, in the fastest route problem, if speed data is collected only from those who own smartphones, then the system result may be more accurate for wealthier populations with higher concentrations of smartphones, and less accurate for poor areas where smartphone concentrations are lower. This otherwise neutral collection of data can have a disparate or disproportionate impact on socially and economically disadvantaged people. This is discrimination. We're going to hear from Nathan about Challenge 2, the actual design of the system. But basically, the issue here is that the technical processes involved in describing, diagnosing, and predicting human preferences and behaviors are completely unknown. There's no transparency. And because we can't see the process, we can't determine if there's been bias or discrimination. The owner of the algorithmic system has a confidential trade secret right in that system. It is not required to disclose it, so we can never really tell what's happening. The owner, organization, or business has what we call intellectual property rights that are here at tension with individual rights to be free from discrimination. According to the Consumer Financial Protection Bureau, as many as 11% of U.S. consumers are credit invisible, meaning they do not have enough up-to-date repayment history for an algorithm to produce a credit score so that they can access credit. Data analytics can actually alleviate this problem by using new data inputs, such as other bill payments like phone bills, public records, education, social media, etc., and can improve chances for otherwise ineligible consumers to receive credit and loans. This could have a positive impact on African Americans and Latinos who are more likely to be credit invisible than whites. But if not used with due care, these new scoring mechanisms could actually make the problem worse and perpetuate or mask discrimination. Remember, the challenges here are data inputs and accuracy, and lack of transparency with respect to the design and workings of the system. As algorithms develop to measure credit worthiness in new ways, it will be critical to design and test them to guard against carelessly using information that's a proxy for race, gender, and other protected characteristics. There may be legal protection here for consumers in negligence law and in federal statutory law, such as the Fair Credit Reporting Act and the Equal Credit Opportunity Act. But it is really challenging for consumers, particularly those with less experience dealing with large institutions or complex data products, to even identify when and if a violation has occurred. New hiring practices use algorithms in place of industrial psychologists and hiring recruiters. It makes sense that an algorithm could be designed to take bias out of hiring, such as the like-me bias that leads people to hire people who are like themselves over others not like themselves. But there is here a risk that since the algorithm is designed by humans, it will somehow incorporate human bias. An example given in the 2016 White House Big Data Report is this. What if a data point used in the algorithm is the age that the job candidate became interested in computing? There are cultural messages and assumptions that associate computing with boys more often than girls. And use of this data point could promote more male hires than female hires. It could skew hiring in favor of men over women. Here we see potential disparate impact, where the use of what seems like a neutral data point, the age at which the person became interested in computers, can have a discriminatory impact on a protected class, women. Existing employment discrimination law, such as the Civil Rights Act, might protect victims of this type of discrimination. But again, because of the transparency issue, unknown data points, and unknown processes, it is nearly impossible for a job applicant to realize she has been discriminated against. This is one of my favorite policy areas to explore because of my role as an academic. Universities hold an enormous amount of data about applicants and admitted students. From financial aid, recruitment, admissions, class performance, extracurricular engagement, etc., students leave digital tracks all over the place. In many cases, universities are not doing nearly enough to share that information across divisions and to use it in ways to improve the quality of education. But that's for another day. The opportunities to use big data in higher ed can either produce or prevent discrimination. The same technology that can help identify and serve students who need assistance can also be used to deny them admission, or, if already admitted, to discourage them from selecting a course of study that they are passionate about. For example, some universities are already using data points to map pathways to student success. In some cases, this has improved retention and graduation rates. Universities can use analytics to try to predict a student's success in a particular major and course of study. The Family Educational Rights and Privacy Act, FERPA, applies to protect student information, but it has not been a roadblock to the use of analytics for universities wanting to apply analytics projects. The 2016 White House Big Data Report does recommend that universities obtain Institutional Review Board, or IRB, approval, as these projects do involve human subjects, the students themselves. Even if universities can ensure compliance with federal law for their projects, there is another important concern here, and that is student autonomy and the right to self-determine a path of study that is consistent with the student's passions, regardless of any algorithmic diagnostic or prediction. We might call this the right to autonomy privacy or the right to identity privacy. I'm just scratching at the surface of this here, but the concern is very real and ultimately involves the individual's right to self-determination and self-creation. We each have a right to create our identity. When institutions or organizations start messing with that right by relying solely on data analytics to direct student growth, regardless of any altruistic intention, they may be committing an act of disrespect. What more important foundational right is there than the right to create your very own definition of self? In this last video, we're going to be talking about criminal justice issues and predictive policing, which you know from your labs in Mod 1, and you'll see in future labs that this can raise some concerns both in law and in ethics. Law enforcement agencies have long been trying to identify patterns in criminal activity in order to allocate resources more efficiently. Today, many police departments use sophisticated computer modeling to identify crime hotspots. One of the issues in this policy area is predictive policing, which is technically defined as, quote, directed information-based patrol, rapid response supported by fact-based pre-positioning of assets, and proactive intelligence-based tactics, strategy, and policy. The data sets in criminal justice can be of poor quality and often are generated with subjective information, such as discretion of officers and prosecutors. To prevent discriminatory practices in this area, it is critical to eliminate data that serves as a proxy for race or poverty to ensure historical bias is not replicated in the algorithmic process. This is essential to ensure that the relationship between criminal justice organizations and communities is healthy. The same issues, lack of knowledge about data used and lack of transparency in the technology, are repeated here and can and do generate community distrust and allegations of discriminatory practices by police. Interestingly, data from body cameras removes the subjectivity of traditional data points used here. There's work being done to make body camera data more searchable and interoperable with other systems, and the White House Big Data Report makes a point of emphasizing the potential benefits of improvements here. In this video, we're going to look at some of the best practices suggested from the White House Big Data Report of 2016 to eliminate bias and to prevent discrimination. So this quote is directly from the report itself. Moving forward, it's essential that the public and private sectors continue to have collaborative conversations about how to achieve the most out of the big data technologies while deliberatively applying these tools to avoid and, when appropriately, address discrimination. Best practice 1, the White House suggests supporting research into mitigating algorithmic discrimination, building systems that support fairness and accountability, and developing strong data ethics frameworks. So you see the usefulness of this course is even more obvious in this first best practice. We're learning about ethics and legal frameworks to prevent discrimination and bias. This learning is essential not only because it's suggested as a best practice, but because we will see as the law does eventually catch up to the technology, those of us who are prepared and understand ethics and legal frameworks will be in a strategic position to do better in this industry. The second best practice suggested by the White House is to encourage market participants to design the best systems, including transparency and accountability mechanisms, such as the ability for subjects to correct inaccurate data and to appeal algorithmic-based decisions. So this practice is coming out of what we know to be issues of the lack of transparency, the lack of knowing about what's happening behind the scenes. And it's meant to encourage those that are in the industry to not wait for legal regulatory reform to be enforced upon them, but to take action and to use design practices to address the problems. The third practice, promoting academic research and industry development of algorithm auditing and external testing of big data systems to ensure that people are being treated fairly. This is a little bit like the second big practice, and I would say that Nathan has addressed both of these practices in his videos and his discussions about design systems and the importance of continually researching and developing in this area. The fourth one, broaden participation in computer science and data science, including opportunities to improve basic fluencies and the capabilities of all Americans. Super important here. So many people are just not really aware at all about what is happening in the big data revolution, that this data is being collected, that it's being used, that there's possibilities of bias and discrimination. They don't know to advocate for themselves. They don't understand the science. So I would say that those of you participating in this course today are ahead of the game, that you're taking a course that's been developed by Microsoft to actually broaden the participation in computer science and data science so that we're learning about this so that we can become better professionals. Universities like Seattle University are also taking a lead in this by designing graduate programs and undergraduate programs in data analytics and law and ethics, so that in learning about the science, we're also learning about the ethical and legal frameworks that are important. The fifth best practice, consider the role of the government and private sector in setting the rules of the road for how data is used. I would also say here that you also have to consider the role of civil society. There are a lot of nonprofits, think tanks, and groups that are involved in understanding what is happening in data analytics and artificial intelligence, and those voices need to be heard as well.
By now, you have heard both terms, descriptive and prescriptive analytics. I want to focus now on descriptive analytics. Predictive and descriptive analytics are similar in that they both depend on massive sets of aggregated data. The difference is in what they do with it. Predictive analytics takes that aggregated data and then uses statistical models to forecast or predict future behavior. Descriptive analytics takes that aggregated data and then feeds it to machine learning algorithms to form a picture of the identity of the person or thing it is trying to describe. So one tries to describe the present or past, and one tries to predict the future, both based on massive amounts of aggregated data. We have already looked at predictive analytics, so what about descriptive analytics? I find it's sometimes helpful when talking about ethical issues to make them as personal as possible. So some questions that you want to know about your own data. What data is being aggregated about me? And is it painting an accurate picture of who I am? And how is the data going to be used? The knee-jerk response many people have is to demand privacy and just insist that no one should have access to their data at all. We'll talk about that problem shortly. It's actually a pretty tricky one. But let's say this. At least if they're going to find out a lot about me, I hope whatever they conclude is accurate. This anxiety that is going in two directions at once is nicely described by Kate Crawford with an analogy. We are worried that our data is like a harsh fluorescent light that shows both too much of us and not enough at the very same time, and therefore displays a false and unflattering picture of us. For one thing, many crumbs of our digital trail depend deeply on context for their meaning. For example, what if you posted a highly sarcastic comment on a social media site that got a quick laugh from your friends, but might make you seem like a menacing person if an algorithm took it literally? I mean, do we know how to make algorithms that understand sarcasm? But what if we give the algorithm something a little less open to interpretation? In a highly publicized 2013 study conducted by the University of Cambridge, researchers were able to train algorithms to discern a user's race, gender, religion, political affiliation, and other personal characteristics with a high degree of accuracy simply by correlating their likes on Facebook. That's kind of cool and has obvious uses for businesses looking to develop new products and politicians trying to craft their message. But when I say high degree of accuracy, I'm not talking about 100%. I'm talking about 90, 80, or 70, or worse. And that should give us pause because, as a matter of fact, there are already many proprietary systems out there trying to figure out who the bad guys are by combing through these massive data sets. Now, I'm all for cops catching bad guys, but you have to wonder, is there some part of your digital profile that is being misinterpreted and putting you on some kind of bad guy list? In response to this, you might say that at least you should have a right to see what descriptive analytics thinks it knows about who you are, and then you should have a chance to challenge those findings if you believe they are inaccurate. Actually, that's also complicated, because let me tell you what the response will be. The users of descriptive analytics will say that access to your digital trail actually lets them know you better in some ways than you know yourself. So, of course, you know things about yourself, such as religion and sexual orientation, because you're the one who defines those things about yourself. But consider this example. Maybe you don't think of yourself as a materialistic person. In fact, you go on rants about the evils of materialism and people spending money on things they don't need, and maybe even post a blog about it. But then maybe an algorithm could tell us how much time you spend online looking at luxury goods and what your past purchases are, and discover that you actually are on the materialistic side. And maybe that surprises you. Maybe you are much more materialistic than you realize. So what users of proprietary descriptive analytic algorithms would say is that allowing you to go back and challenge the characteristics that they have discovered about you is going in the wrong direction. Descriptive analytics tells us things about yourself you might not know. So, do we have identity rights in this new world? Will governments have a standard of due process similar to the one they have for the physical world? As Eva has been pointing out, there is currently no laws governing this space. So, we'll have to see.
The human right to privacy is quite simply the right to be let alone. There are two aspects to this right: decisional privacy and informational privacy. Decisional privacy is the right to be let alone with respect to how we live our lives, who we partner with, how we raise our children, what medical treatment we accept and reject. This right is most affected by government actions that attempt to restrict the full expression of privacy by citizens. For example, attempts by states in the United States to restrict the right to reproductive freedom for women raise the issue of the right to privacy, and because these cases are about government restrictions, they concern the right to privacy as it is protected by the U.S. Constitution. Informational privacy is the right to be let alone with respect to information or data that reveals knowledge about us. Sensitive information such as social security numbers, race, gender, religion, health data, including fitness levels, genetic data, all of this information reveals a part of who we are. Outside of constitutional protections against government actions that restrict our privacy, most of the law that protects privacy, particularly informational privacy, is protected by sector in the United States. There is not one overarching rule that otherwise protects individuals from having their information accessed, used, or shared without their consent. Instead, the statutes protect sectors of information. And so there are laws that protect our health data, our financial data, student data, credit data, and even our genetic data from being accessed, used, and shared without our permission. The limitation of these laws is that they are very specific. For example, the Genetic Information Privacy Act, otherwise known as GINA, protects against access, use, and sharing genetic information by employers and insurance companies. In the context of new technologies such as data analytics and AI, these existing laws will need to get stretched in their application. Finally, in the U.S., there is common law that protects privacy in an area of law called torts. We've already seen torts in our discussion of negligence law. Tort law, intentional tort law, protects individuals from wrongs committed by another that cause physical, financial, and emotional harm. When a person or organization intrudes into areas where we have a reason to expect privacy, or accesses and shares personal information that we expect to be able to keep personal, then there may be a civil lawsuit claiming damages for that harm. All this said about privacy law in the U.S., the current story of U.S. privacy law may be that at least Americans consider it to be more of a privilege than a right. The willingness of individuals in the United States to share forward their information in transactional exchanges online, in fitness challenges at work, and on social media like Facebook, Twitter, Snapchat, and dating sites suggests that there's an evolution of how we consider information that is intimately personal to us. What happens, however, when we come to learn that all of this personal data is being accumulated to create what privacy scholars like Daniel Solove call digital biographies about us, and all of a sudden technologies are having a hand in defining the very persons that we are, because we are so willing to share that information, it becomes harder to argue that we have any expectation of privacy in the data at all. The sources of U.S. privacy law are identified here on the screen for you. We've talked a little about the U.S. Constitution, and we're going to talk more about statutory law that comes up mostly in a business context. We'll identify that in Mod 3. For purposes of the video here and in Mod 2, where we're talking about the relationship of the individual and society and data analytics and artificial intelligence, we're going to focus on the common law source of privacy law in the US, which is tort law. Tort law is law that protects us from emotional harm, financial harm, and physical harm. It is state law. It's common law, meaning we find the rules of law in the cases that we read about what these torts are. So these have all been created. These torts were created by our court system in the United States. There are many scholars that are looking at tort law as one aspect of privacy law that might be very successfully used to protect individuals from the use and misuse of their data. The answer to this question is still outstanding. We don't know the answer, but we're opining at this point that this may be an area that we can find some protections for individuals who feel that their private information has been used and misused in a way that causes them emotional, physical, or financial harm. There are 4 intentional torts in privacy: intrusion into seclusion, appropriation of name or likeness, public disclosure of private facts, and false light. Each one of these addresses specific different aspects of privacy, but what they have in common is that in each case, we have to be able to identify that the individual who's alleging harm had a reasonable expectation of privacy. That's not always easy in this new technology, but it's definitely mandatory that we are able to show that. So intrusion into seclusion, the first one, basically is what it sounds like. You are intruding, someone has intruded into the seclusion of somebody else. Classic case, people in a women's dressing room and somebody is peering in unwantedly into this private area of the dressing room space. In the context of new technologies, some are arguing that the Internet of Things, in particular, this interconnected network of sensor data from consumer devices like Fitbits and smartphones and smart appliances and so forth, that the misuse of that information might result in an intrusion into seclusion. It's a tough argument because you have to show that there has been an unconsented to use of it, and you also have to show that it is highly offensive to a reasonable person. But we're going to revisit this in Mod 3 when we look at some of the statutory protections as well in some of the cases related to the Internet of Things, particularly those that have been addressed by the FTC. The second one, appropriation of name or likeness, or sometimes called misappropriation of name or likeness, protects our identity. So if somebody uses an aspect of our name, likeness, picture, identity to their commercial advantage without our permission, that is an appropriation, and that's a privacy violation because we have an expectation of privacy in our identity. Classic case is somebody taking a picture of a famous person and putting it on t-shirts that they then sell to their commercial advantage. In the context of new technologies, there's a question of whether or not data brokers, other entities, organizations in this new space who are using parts of our identity, if that is an appropriation. If it has been unconsented to, it could be, but it's not clear because the commercial advantage piece has to be established. And again, we have to also show that there's a highly offensive misuse. The third one, public disclosure of private facts, occurs when somebody discloses private facts about another, and those private facts are highly personal. The disclosure is public, and it is highly offensive to a reasonable person. So if somebody discloses to a community that their neighbor has a highly infectious disease without their consent, that might be considered the public disclosure of a private, albeit true fact. Because it's offensive, it's a violation of that person's privacy and private life. In the new technology space, in data analytics, artificial intelligence, there can be aspects of this that happen as well, where things about us that are true but private come out. Again, questionable whether or not in this age of sharing forward so much information about ourselves, we can argue that we're offended because we share so much. But at least some scholars are saying there's a possibility here that this kind of disclosure could be actionable in this new technology arena. The problem here is that the publicity piece is not clear. Publicity isn't necessarily equated to the trading of our information. So when data brokers are trading forward our information, is that publicity? Is it highly offensive? It's not entirely answerable at this point. The last one, false light. This occurs when a person is put in a false light, either it has to be publicly, but it has to essentially just a misalignment of who we are. So taking a picture of somebody and putting them under a headline in a newspaper that says something that is false would portray that person falsely. This one is really, really new in data analytics and artificial intelligence. We haven't seen a lot of it, but again, it's possible that you could be falsely portrayed certainly have seen cases where our data has resulted in false information and false conclusions about us that we are falsely portrayed, and that causes an emotional, physical, or financial harm to us. Still, we have yet to see any of these cases. No data traders have been sued under U.S. tort law, to my knowledge. This is all speculation, but to the degree that we can stretch these torts a little bit more than we can stretch statutory law, there's argument that there is protection here for individuals. We're going to learn about negligence law in this video. Negligence law is state law. It is sourced in judge-made decisions, so it's common law, and it is relevant to all kinds of behavior, including personal behavior and business behavior. The thing that is really interesting about negligence law is that if you understand the basic elements of negligence, then you can see how it can be applied to any kind of behavior. And we'll see some examples of that, including behavior in data analytics and artificial intelligence and the management of data and use of that data. So the basic elements of any negligence claim are these four: duty, breach, causation, and damages. The duty that we all have is the duty to act as a, quote, reasonable person under the circumstances. That means that we are to act carefully under the circumstances of whatever it is we're doing. For example, if you are driving an automobile, you are under a duty to drive that automobile reasonably under the circumstances of the day that you're driving, which may change. So on a day that is clear and sunny, it might be reasonable to drive the speed limit. On a day when it is cloudy or raining or there's storms, then it might not be reasonable to drive the speed limit. So the circumstances change, and it is ultimately the courts that decide what these duties are and how they're defined, which is why we read cases to understand the court's interpretations in the various contexts. So we always are under a duty to act carefully. We breach that duty when we fail to act carefully. So if I'm driving a car and I'm driving excessively over the speed limit on a day when it is cloudy and stormy and I cause an accident, then I have failed to live up to my duty. I have breached my duty to act as a reasonable person under the circumstances. Causation is the link between that breach and the damages that are caused. It's a factual inquiry and also a legal inquiry, but it's basically looking to see that there's some connection between the failure to act reasonably and the harm that was caused. In negligence law, negligence is tort law, which basically is law that protects us from emotional, physical, and financial harm. The damages are that. They can be physical, they can be emotional, and in a business context, they can be largely financial. So these are the four basic elements of any negligence claim. Now, it's important to understand negligence because these can come up as claims in different contexts, including negligent product design. So we might talk later about, in the context of artificial intelligence and things like, self-driving cars, who designed that car, who designed that vehicle, was it designed carefully? Negligent product design can come up as a claim when a product is not designed carefully, and as a result, it causes harm to the person using the product. You can be negligent in hiring. So if companies are not careful in hiring, then they can be accused of negligent or careless hiring in the event that the person hired actually causes harm to another. Negligent distribution can be negligent distribution of products. If I'm a marketer and I'm distributing products, if I don't do so carefully, then I might cause harm and be responsible for that. We've seen these cases in allegations, for example, against gun manufacturers who might be distributing guns in areas where there is less regulation to their access, knowing that they might flood up into a black market and become more available, causing harm as a result of criminal activity in those places where the regulations were stricter. So again, we can be careless doing anything: product design, hiring, distribution, and, relevant to our course content here, negligent data collection or management. There can be a claim that the data broker, the data user, is collecting information in a way that is not careful enough, or that they're managing the information, sharing the information in a way that is not careful enough. So if we consider things like big data breaches, there's negligence there. Those are allegations of negligence as well as violations of other federal statutory law. But just in the carelessness realm, we need to be careful in how we collect, manage, use, share, and so forth the data that we are accessing in data analytics and artificial intelligence.
If you look at the way the word democracy is constructed, it comes from two Greek words, one being people, demos, and the other being power, kratos. So in a democracy, theoretically, the common people are the ones with the ultimate power. And business corporations are legal creations. That is, they came into existence only because a government decided to allow them to exist. So in the abstract, people have power over government, and government has power over business. Now, I think most of us know that's an ideal. Even in a fairly healthy democracy, it's not going to be difficult to find examples when the government has an unhealthy amount of power over a particular individual or group. It will be equally easy to find examples where the government is unable to control a particular business, even when the business is doing something unethical, even though the government might be generally a well-functioning one. Part of the reason is because when I refer to power, I don't mean complete control. Rather, I mean something like final authority. The people have the right to change their government if they don't like it, and the government has the right to regulate business activity and tax it in the interest of the people. So we need to fine-tune our understanding of power in this sense. It means final authority, not complete control. And I believe that the record of history shows that the healthiest societies are the ones where the common people have final authority over the government, and the law gives government final authority over business organizations. But something is happening in only the last few years that has totally changed this balance. There's a saying that knowledge is power. It seems that this saying rings true on many levels. But perhaps it's time to revise this generally true saying by making it more specific. Yes, knowledge is power, but these days you get knowledge from data. And so maybe a more to the point saying is data is power. Now that should make us think, because the time-tested formula, people have authority over government, government via law has authority over businesses, that doesn't seem to fit. Because currently, businesses are the ones with the data. And government can pretty easily get data on its citizens, but it usually has to ask the businesses to cooperate by giving away their data. So it seems that the government has a level of power over its citizens that it never had before, because it suddenly has a ton of our data, but we have very little data on the government. There are small examples of citizens getting government data, such as the Freedom of Information Act, or FOIA, where citizens can request certain data from government, and the government is legally obligated to give it over. In fact, this is how the recidivism data set that we are using in our labs was obtained. But these examples are few and far between. It's mostly the case that government has our data and we don't have the government data. And businesses have a lot of data that the government would like to have. It sometimes tries to force business to hand over that data, but business does not always comply. So if you think about it, we are now entering a new era of history where business has a kind of power over the government that it never had. And government has a kind of power over its citizens, at least to a degree, that it never had before. It would be one thing if this were a slow evolution that we all had time to adjust to, but this is all happening at a speed that we can't really even conceptualize. It is a revolution in knowledge distribution, and it's important that we understand and talk about this power shift.
In this video, we're going to go through an exercise, our exercise for Module 2 in IRAC, which is a legal critical thinking exercise to help us understand how to spot legal issues and work our way through to a conclusion. So if you remember, IRAC stands for Issue, Rule, Application, and Conclusion. We always start out with a story. This story for Module 2 IRAC is tied to the content that we've learned in Module 2 about the law that's relevant to individuals and identity and privacy. So the story is about Facebook, which is a social media firm. And in this story, we learned that one of Facebook's advertising practices, which is called sponsored stories, has, according to some of its members, taken pictures of the members and identified them with particular advertisers based on likes. So a group of 50 members in this story have identified that Facebook has taken their names and their pictures without their knowledge or consent and used them for a sponsored story to promote advertisers that are in a contractual arrangement with Facebook. They claim they suffered harm, and as a result of this harm, they want to sue Facebook. That's our underlying story. Now, the issue here, or the legal question, is whether Facebook violated its members' rights to privacy when it used member photographs to promote the sponsored stories advertisers. That's our legal question to consider. The rule here, as we've learned in Module 2, is about privacy torts. The privacy torts include the 4 distinct intentional torts. The one that's applicable here is called appropriation of name or likeness, and it should sort of jump out at you, like when you hear that somebody has taken somebody else's identity or an aspect of their identity and used it to commercial advantage, you're going to think, oh, that sounds like the appropriation tort. It happens when there has been a taking without permission. It's considered an invasion of privacy. So the tort defines invasion of privacy as occurring when one party, without permission, takes an aspect of the person's identity and uses it for commercial benefit. The harm recognized here is mental distress of the person whose identity was used or damage to the value of that person's identity. Now, in the application piece, this is really where a lot of the logic happens. You're going to take the rules that we've identified and apply them to the facts of the case. The question here for you would be, how would you apply the privacy tort of appropriation of name or likeness to the story of this case, the story of the 50 Facebook members who had their pictures used in the sponsored stories advertisements? What conclusion would you reach if you were the judge deciding the case? This is a real case, actually. And in this real case, it was in California State Court, Facebook wanted to have the case dismissed, and I believe was arguing that there was no claim here for a misappropriation, but ultimately the company settled with the plaintiffs, and that means that we don't know what a court would have decided. The court was letting the case go forward, meaning they were recognizing that the plaintiffs, the 50 members, should at least be heard in court, but at some point Facebook just decided to settle with the plaintiffs, settled out of court, so we don't know entirely what that decision would have been, but you might for yourself reason and think about, do you think that this is a misappropriation of name or likeness, or do you think that the plaintiffs did not really have a claim against Facebook in this case? I'll leave that for you to decide.
In our previous module, we had talked about how data relates to the individual and society, and issues and opportunities around bias and privacy had come up. But as we move in this module towards more about businesses and actual corporate entities, I can only imagine how those become more impactful and important to discuss. So Eva and Nathan, could you tell us about this module and what students are going to learn?
Yeah, sure, absolutely. In this module, we're going to be turning our attention from individuals in society to businesses as the dominant player in artificial intelligence and data analytics. And we'll see that unlike the earlier modules where we're looking at law in general and sources of law, the Constitution and statutes and case law, here we're really looking at regulation. At least from the legal perspective, we're looking at how is business regulated in data analytics and artificial intelligence. So we'll look at some US laws that apply, we'll look at European law that applies, and also see how there's some conflict because the law predates all of this technology. So we've got that ongoing theme of how is the law going to be interpreted with respect to these new technologies?
Got it. Yeah, so as well as regulation, we have this other side of perhaps responsibility, right, of what not only companies shouldn't or should do from a legal perspective, but what are they actually called to do as an organization? So
yeah, great transition to Nathan and to the ethical frameworks, because what we call corporate responsibility or corporate social responsibility or corporate citizenship even is looking at more than what the law is going to require. So remember that the law is the moral minimum. It sets a minimal standard for the businesses, but what Nathan's going to be teaching in this course, in this module, the course is actually speaking more to the responsibility side.
Got it. Cool.
Yeah, this is such a huge and interesting topic. You can't overestimate how important this is. So we have this discipline, business ethics. It's near and dear to my heart. It's the class I teach the most. And the way people think about business is all about greed and exploitation. And they think about ethics as being kind. And they're like, how can business ethics, how do those two words even go together? But it turns out lots of interesting ways. That's not a very good way to understand business or ethics. So we talked about the 5 specific ethical values. And it turns out that trust and character excellence, but now it's translated as culture excellence, turn out to be very important for ethics at an organizational level. And what's definitely true is that there's lots of moving pieces with business, but every one of those pieces is totally being transformed by data and AI. So it is very important to have these conversations, and this was my favorite module to work on with you guys. It's a very important conversation, and I hope this gets people thinking.
Yeah.
Excellent. Thank you both. Yeah. And we look forward to joining you. Thank you.
In this area, we are talking about customer analytics and the legal protections for customers in the U.S., mostly with respect to privacy and security of data about them, and how that data is used appropriately or not in ways that affect their lives. In this video, I'm going to introduce the Federal Trade Commission's role in this area and highlight 2 laws that have been used to protect consumers, and also provide you with 2 case examples. The Federal Trade Commission is the federal agency charged with protecting consumers under the Fair Credit Reporting Act. The Fair Credit Reporting Act applies to companies known as consumer reporting agencies, or CRAs, that compile and sell consumer reports, which contain consumer information that is used for credit, employment, insurance, housing, and other similar decisions. CRAs must implement reasonable procedures to ensure maximum possible accuracy of consumer reports and provide consumers with access to their information and the ability to correct errors. This is an area concerning the relationship between law and technology, where we see the law being stretched to apply to technological advances. Data brokers might not otherwise consider themselves subject to this or any other law that protects someone else's customers, but based on the enforcement actions taken by the FTC, they are now on notice. For example, the FTC entered a consent decree with the online data broker Spokeo. Spokeo assembles personal information from hundreds of online and offline data sources, including social networks, and merged that data to create detailed personal profiles, including names, addresses, age, hobbies, ethnicities, religion, and mark these digital biographies for use by human resource departments in making hiring decisions. According to the FTC, Spokeo's actions made them a CRA, and as such, subject to the rules of the FCRA, which they were not following. They paid $800,000 in penalties. Note too that Spokio had tried to protect itself from the risk of having to comply with the FCRA. It included a disclaimer on its site which claimed it was not a CRA and that users should not use their site for credit eligibility purposes per se. This disclaimer was not effective to protect the company from FTC enforcement action. This is a good example of what is a central objective of this course with respect to regulatory law. That is, organizations and participants in data analytics and AI should not assume that existing law does not regulate them. The FCRA predates this new technology, but as this case example shows us, federal authorities can apply existing law to new ways of conducting business. Data privacy and security are top of mind for the FTC. In addition to enforcement authority for the FCRA, the FTC also uses Section 5 of the FTC Act to take enforcement actions for violations of consumer privacy rights. Section 5 is generally applicable to most companies acting in commerce, regardless of market sector. Section 5 of the FTC Act states that unfair or deceptive acts or practices in or affecting commerce are unlawful. Unfair and deceptive practices can arise when companies are maintaining large amounts of sensitive data about individuals and are not securing it from misuse. The more sensitive and complex the data, the more security should be in place. Companies can be held liable for failure to secure or for sharing or selling data analytics products to customers who may use that data for fraudulent purposes. One recent case in this area relates to the Internet of Things, that all-encompassing network of internet communication connecting everyday consumer devices. TrendNet provides cameras for consumers to conduct safety monitoring in their homes and allows consumers to access live video and audio feeds from their cameras over the internet. The TrendNet action was brought by the FTC because TrendNet misrepresented its security measures to consumers and failed to use reasonable security measures to prevent unauthorized access. As a result, hackers were able to compromise the live feeds and gain access to surveillance inside customer homes, including viewing children sleeping and playing and adults engaging in daily activities. This also allowed access to information inside the home and the potential for larger threats like robberies and other kinds of things that could happen with that information. The FTC has not issued formal rules for the new data security issues that are being created by data analytics, the Internet of Things, and AI, but rather uses existing law to enforce its authority through complaints and consent orders. A great resource for organizations concerned with legal compliance is the 2016 FTC report suggested as additional reading for students in this course. The report is called Big Data, a Tool for Inclusion or Exclusion. Take a look at the list of questions on page 24 of that report, which will help you begin to roadmap legal compliance for customer concerns in the United States. What should also be on the radar of organizations and participants is forthcoming law that might be passed to address regulatory concerns in the U.S. government in situations where no law yet exists. In this video, we're talking about regulations in the United States that apply to employees to protect them from discrimination and other misuses of their information. There's a list here for you to see that the main laws that apply in the U.S. to regulate and protect against employee discrimination. And so in this area, we're talking basically about people analytics. How do we protect people in the context of analytics and artificial intelligence? Looking first at existing law to see what the law requires, and then considering instances in how the law will be applied to new technologies. So I'm not going to talk about all of these laws. I'm just going to highlight a few things for you. Title VII of the Civil Rights Act of 1964 is our primary law protecting against employment discrimination on the basis of protected characteristics. So generally in the U.S., if you fall into a suspect classification, and all of us fall into at least one, then you are protected from employment decisions based on that harm you on the basis of your membership in that protected class. The protected classes are race, gender, religion, and so forth. Title VII covers a host of the protected classifications. Then these other laws, the Americans with Disabilities Act, that protects those who are disabled, and disabled is defined very broadly, from decisions that are made that harm them in employment, whether it's not hiring, firing, demoting, or whatnot. Anything that is done to a person, an employee, with respect to a disability would be covered under the ADA. The Age Discrimination in Employment Act, just to let you know what that is based on the classification of age. And in the United States, under this regulation, if you are over 40, which doesn't really seem like it's that old, but if you're over 40, you are protected from employment decisions that cause you harm on the basis of that age. The last one, the Genetic Information Non-Discrimination Act, is super interesting. This was the most recent of all of these laws, and it was passed by the U.S. Congress because what was happening was employers and actually insurance companies on the consumer analytics side, but employers were using genetic information about their employees or their potential hires to make decisions about hiring, firing, promoting, and so forth. So you can imagine that if an employer gets access to your genetic information as part of a pre-employment physical and then decides, in fact, not to hire you because you have the genetic marker for prostate cancer, then that would be discrimination. Now, there was no law that protected us from that before GINA. Now that we have GINA, employers and insurance companies are not allowed to use that information to make employment or insurance decisions about us. So looking at these laws, we realize that, again, they were written before technology advanced. And so we're going to be concerned to see whether or not we can stretch them in their application to these new areas of analytics and artificial intelligence. The classifications under Title VII. Title VII is the one I'm going to focus the most on here today. These are our protected classes: race, ethnicity, national origin, gender, and religion, all protected under Title VII. So if you are treated differently or you experience some sort of employment harm and you are a member of one of these classes, and in fact the decision was made because of your membership in the class, then that is discrimination that is prohibited by Title VII of the Civil Rights Act of 1964. The theories here of liability there's two, and these theories we see consistently across laws that are protecting us from discrimination in every context. So it's important to understand them here with respect to Title VII in the employment context. But you've seen and we've heard and talked about these different theories in other contexts. Anytime there's an issue of bias or discrimination, these theories actually are relevant. So disparate treatment and disparate impact. How are these two things different? Disparate treatment with respect to Title VII is actually considered intentional discrimination. If you are not hired because of your membership in a protected class, that is considered intentional discrimination or disparate treatment, treating you differently on the basis of your membership in that class. In data analytics, this might come up if an employer disfavors a particular group, has made some conclusions based on analytics that certain group of people will be less desirable as employees. For example, we've talked about markers that might reveal that a person is more likely to quit in the first 5 years, or is more likely to be less productive, or whatever the conclusion is. If an employer is taking that conclusion and treating a group differently on the basis, that's intentional harm. Now, unfortunately, if the group isn't one of these protected classes, that's not considered a problem under Title VII. So we don't really see a whole lot of Title VII issues come up in analytics and artificial intelligence. What we do see, at least with respect to disparate treatment, we do see more of the disparate impact case in analytics and artificial intelligence. And disparate impact is unintentional discrimination. Basically, this happens when neutral information is used, but although it's neutral, it is impacting members of a protected class differently than others. So historically, in Title VII cases, disparate impact would come up when an employer is using a certain kind of test to determine eligibility for a job. So if a job requires that you are able to lift 100 pounds of weight, you might have to pass a test for that to see that you are physically able to do what the job requires. A lot of scholars are using disparate impact theory to talk about the potential for bias and discrimination in employment in this area, but it's not entirely in alignment, because when we're looking at analytics information, it's all information, it's all variables, it's all data. So we're not actually looking to correlate necessarily the data with what the job requires, but to the degree and extent that this is all we have for employment protections under Title VII, disparate impact is really going to be the theory that gets a lot of attention to see if groups are being disfavorably affected as a result of using algorithms, for example. And as we talked about in Mod 2, it's one thing to understand that this can happen and to know that it can happen. It's another thing to actually really be able to identify it, because there's really no transparency here. So an employee who has an impact might not even realize that he or she's been discriminated against in the first place. But things to look at, and these two theories are really important to learn. And if we understand them, we can see how they come up really in all law that protects us from bias and discrimination.
If you've spent much time in organizations of any kind, you likely know how great it is to have a good boss and trustworthy coworkers. You've also probably had the opposite experience, and so you know that bad bosses or bad coworkers can make a work environment nearly intolerable. And you probably won't be surprised to learn that in studies, healthy work environments are positively associated with productivity, and vice versa for toxic work cultures. So it's really easy to appreciate why businesses are so concerned to hire the right candidate. This is the basic problem that keeps human resources managers up at night. There have always been major barriers to hiring the right person. First of all, it's really hard to tell from a resume, recommendation, and a half-hour interview if the candidate in front of you will be good for your organization. This is the basic problem of measuring the qualitative. We know, both through research and basic everyday experience, what qualities are desirable in a worker. For example, emotional intelligence. But it's really hard to find a way to measure that. Then there's the problem of bias. In all societies, there has been a significant bias against hiring women. And in the US, there's also been a major hiring bias against people of color. And of course, the truth is that an equally distributed number of those victims of bias would have been great bosses and wonderful coworkers. So wouldn't it be just great if an algorithm existed that could find the ideal employee? And even better, this algorithm wouldn't be biased against women and people of color, right? It probably won't surprise you to learn that there are many such algorithms already in use. And there is now a full-blown discipline called people analytics, and sometimes HR analytics, standing for human resources, that studies how algorithms can be used to find those great candidates. The experts on people analytics predict a complete change in how organizations find employees. Has people analytics brought the revolution it promised? Well, there is evidence that these algorithms are doing a pretty good job so far. In the further reading section of the module, you will find a link to a white paper published by McKinsey that details some of these successes. But remember, a theme of this course is that all revolutions have both winners and losers. In particular, there are two issues that should trouble us from an ethical perspective, and these issues are in tension, such that the solution to one tends to butt up against the solution to the other. Machines learn from data, so people analytics algorithms learn from whatever data we provide them. On the one side, the most obvious kind of relevant data about a potential worker is his or her employment history. But when algorithms read this data, all of the long-standing human biases of the past are imported into the algorithm through the data. So the algorithm learns from past data regarding women and people of color without knowing the fact that the data was created in a context of bias. So far, we are not sure how to tell the algorithms about the context. So even though employment history data is extremely relevant, it is tainted by bias. One way to address that problem is to find data that does not have to do with employment history. If you remember from the lesson on customer relationship management, this amounts to finding proxies, bits of data from your digital trail that are not obviously related to your employment or work history, but are used as predictors of success in the workplace. Everything we were worried about then still applies. The overall worry being that for all we know, your digital trail may paint a badly inaccurate picture of you. For example, the algorithms might learn to avoid people with a 6-month gap in their employment history. But maybe at one point you took off 6 months to care for a parent or child. Or maybe because you have a highly specialized job, it took 6 months to find a new one. The algorithm wouldn't care about the context, it just sees the 6-month gap. Now let me be clear, I have no idea if the 6-month employment gap is actually a proxy being used by people analytics. But perhaps that is the point. We just have no idea what these proxies are. It would be a real harm to the organization, but more importantly, to you, if you were excluded from a job or even an entire job market because of some irrelevant proxy. We assume that we more or less understand ourselves and our reasons for the decisions we make. So when it comes to choosing to buy or not buy something, we assume that we are doing so for reasons that we ourselves understand. It turns out, however, that people in general are strikingly irrational in surprising ways, especially when it comes to money. In a series of books and talks, Dan O'Reilly, professor of psychology and behavioral science at Duke University, argues that we do not know our own preferences very well. One unsettling thing about this is that if we suppose that there are people out there who are able to influence our preferences without our awareness of it, they can actually hack our decision-making process. We think we are in charge of our decisions, but that might be less true than we think. This fact of the human condition is sometimes used for social benefit. For example, behavioral economists advise governments on how to get people to save more for retirement, or to volunteer to be organ donors, or to be more honest on financial disclosure forms. Likewise, for-profit businesses can use these psychological insights for good, or at least in ways that are good for their investors while not being overly harmful for their consumers. Most of us realize that things cost $4.99 because the brain interprets $4.99 as closer to $4 than to $5. And we all suspect that the outrageously expensive TV is probably just put on the shelf to make the TV we're actually interested in seem like a good deal. Businesses have always used little tricks like these, and most of us aren't particularly offended by such practices. But the history of marketing is littered with practices that we have to call manipulative. One recent marketing firm noticed that women feel the least attractive on Monday morning, and so recommended that makeup companies spend most of their advertising dollars at that exact moment of vulnerability. Many people are, if not outright offended, at least a little bit uncomfortable when they hear about marketing techniques that exploit our vulnerabilities. Offensive as it may be, however, when marketing departments were limited to TV and radio ads, direct mail, billboards, their powers of manipulation were very limited. But Ryan Cowlow, in his 2014 article, Digital Market Manipulation, explains how big data makes manipulation strategies such as selling makeup on Mondays much, much more serious. One reason he gives is because big data allows businesses to combine the two ingredients for traditional marketing: personalization and systemization. An example of personalization occurs when a car salesman notices the signs of a middle-aged crisis in one of his customers and uses smooth language to get him to buy a wasteful car that makes him feel more youthful in that moment. This is personalization because this particular selling strategy would not work on most people. Systemization describes a general marketing strategy, such as a car commercial on TV that is intended to provoke a feeling of youthfulness. But in the age of big data, systemization can be combined with personalization like it never has been, and this is because of big data and the algorithms that process them. Most of us have experienced this when an online seller uses an algorithm to give us a list of books we might be interested in based on what book we have already looked at. This may lead to a win-win. The business algorithm helps me discover books I like, all the while they make money. But what if these algorithms can track your digital trail more widely and, for example, use patterns of your likes on social media to know when you have had a hard day and market a harmful, tempting product to you at that exact moment of vulnerability? This is why it's more important than ever that we think about marketing in the digital age from a legal and ethical perspective.
The relationship between privacy law and technology has been evolving since the 1970s. In both the US and Europe, the first generation of modern privacy and data protection laws grew out of the increased use of computers for information processing by governments and businesses. Harvard law professor Urs Gasser recently published an article which traces the history and opines about the future direction of this relationship. The laws of the 1970s were anchored in a set of fair information practices, which are still arguably universally accepted as foundation principles to protect individual privacy rights. These 5 principles concern access to stored records, transparency of process, control options for individuals, and security. We see these original principles incorporated later in the 1990s with the widespread adoption of internet technology and the wave of legislation and regulations aimed at dealing with privacy concerns. And even more recently, in more ambitious privacy codes and laws, such as the OECD's privacy guidelines at the international level, the General Data Protection Regulation in the European Union, and the proposed Consumer Privacy Bill of Rights in the US. Today, we are experiencing even more rapidly advancing technologies and applications such as cloud computing, analytics, and AI. And as we know, there is just no way for law to keep the pace of development with technology. The law-technology tension theme is present in privacy with a capital P. But Professor Gasser has an intriguing proposal that reimagines the relationship between privacy law and technology. He uses the term privacy by design to describe an umbrella philosophy that promotes a means to manage privacy challenges from emerging technologies. This is a holistic privacy risk assessment model that relies on modeling approaches from information security and an understanding of privacy that is informed by multiple disciplines, including statistics, computer science, law, and social sciences. This privacy by design is a collaboration of law and technology. I have to agree with Professor Gasser when he says, and I quote, "Traditional legal approaches for protecting privacy while transferring data, making data release decisions, and drafting data sharing agreements, among other activities, are time-intensive and not readily scalable to big data context. Technological approaches can be designed with compliance with legal standards and practices in mind in order to help automate data sharing decisions and ensure consistent privacy protections at a massive scale." We have seen similar proposals for design solutions to legal and ethical issues in this course already. Privacy by design is a way for law and technology to have a mutually productive relationship. As Professor Gasser states, and again I quote, "Taken together, the development of privacy tools that aim to integrate legal and technical approaches could help pave the way for a more strategic and systematic way to conceptualize and orchestrate the contemporary interplay between law and technology in the field of information privacy." In this presentation, we're going to be highlighting some of the suggested best practices based on the FTC's enforcement actions with respect to the Internet of Things. There are 2 attorneys from the law firm of Kelly, Dry & Warren, Alyssa Hutnick, who's a partner in the DC offices, and Crystal Skelton, who's an associate in the LA offices, who have basically put this presentation together, and we're sharing it forward with you as our students because we just think it's got some really, really good suggestions for how to manage and navigate the regulatory actions that we're seeing coming out of the FTC. So I'm not going to go through all of this presentation with you in this video. You are welcome to go through it yourself. I'm going to highlight some of the slides and speak to those, and then I'm going to ask you to return to them later and really take a deeper look. So first do's and don'ts on this list is to know your data. Some of these are very obvious, but they're really good reminders. You want to understand the devices that you are using to collect the data, how it's being collected, and so forth. The FTC takes an expansive view as to the types of data it considers personal, and quite frankly, they are probably just as motivated, as the European Union is in Europe, with respect to protecting consumer privacy. We don't talk about it as much because the European Union is getting a lot of attention for its recent regulation and us getting ready for that. But the FTC, as we can see from the cases that we've talked about, is very concerned with security and privacy. So know the data, know that they take an expansive approach to it. Don't avoid a privacy by design approach. We've talked a lot about this. Europe's going to require it. The FTC wants to see it. This is where technologists, computer scientists, engineers, lawyers, and ethicists are working together to create technology that is going to have built into it consumer privacy protections. Third one on this list, do consider whether and how users should be provided notice and choice. The clearer, the more user-friendly, the better. And 4, do have a privacy policy covering the Internet of Things device and ensure that it's accurate. We've seen from the case examples in an earlier video that the Internet of Things can create all kinds of interesting privacy issues. And knowing that you have a privacy policy in place and that it's constantly updated is going to be critical. I'm going to go through one more of these slides and the do's and don'ts for privacy, and then we're going to fast forward towards some of the general ones. Number 5, don't forget to update your privacy practices, which is what I was just saying earlier. You're going to have the policy, make sure you update it to be consistent and current with what you're doing. The next few slides talk about security, and at the end, these two counselors have included for us some general do's and don'ts. Number 11 of the general do's and don'ts, do apply extra scrutiny when it comes to collecting sensitive data. We've been talking about the difference between personal data and sensitive data, and the sensitive data, the more sensitive it is, the more secure it has to be. Lastly, I want to highlight this last slide. Don't forget to monitor new developments at the FTC. I can't enforce enough that you've got resources at your disposal. The FTC website is amazing and including all kinds of information about their interpretations of the FTC Act, cases, consent decrees, and so forth. So do make sure that you check that out. And good luck to you. Take a look at the whole slide presentation and make sure that you understand all that is included here for you. Thank you. In 2016, the European Parliament, which is the legislative body of the European Union, enacted a sweeping data privacy law called the General Data Protection Regulation, or GDPR. Since the 1990s, the European Union has made it clear that privacy is a fundamental right for people in Europe. In fact, unlike our US law, which, as you recall, approaches privacy by regulating access and management of personal data by sector, such as health data or financial data or student data, the European Union has taken a very expansive approach. Prior to the GDPR, the EU had implemented a privacy directive in 1994. That directive covered all personal data in the EU and had clear requirements. So why did the European Parliament pass a new data protection law, you might ask? Well, the GDPR permits regulators to fine corporations for non-compliance in excess of 20 million euros, or 23 million US dollars, or 4% of global revenue, whichever is greater. That's a huge number and a lot more than what was allowed under the previous law, the Privacy Directive. What's more, companies without a physical presence in the European Union may be subject to regulation and liability. We learned about the term extraterritorial in Mod 1. The GDPR is extraterritorial to the extent it is regulating companies and processes that occur outside of the physical territory of the European Union. The concern of the EU seems to really be with respect to personal data transfers outside of the EU. The EU does not trust that other jurisdictions, like the United States, will regulate data as protectively as it does. Past attempts to reach agreements on ways to protect data flows outside of the European Union have been invalidated by the European Union Court of Justice because those agreements fail to adequately protect EU citizen rights. So what do businesses need to know about the GDPR? First, it applies to more businesses than the EU Privacy Directive. That is because it applies to all data processors, those who collect data, and everyone in the chain of service distribution that handles it, regardless of where the business is actually located. So a company processing in India information about individuals from France for purposes of predicting their creditworthiness score would be subject to the reach of the new law and need to comply with its rules and regulations or face high financial penalties. Second, the definition of personal data has been expanded to include a person's name, location data, online identifiers, and genetic information. Third, there are severe penalties for non-compliance, as I said, 4% of a company's gross worldwide revenue or 20 million euros, whichever is greater. Factors considered in fining include whether the company acted negligently or intentionally. We learned about those theories in Mod 2. Remember, intentional behavior is purposeful and negligence is carelessness. Finally, data controllers must notify supervisory authorities within 72 hours of discovering a data breach. That's a short window of time. In addition, the GDPR has additional technical and process requirements, which have many corporations vested right now preparing for implementation of the law in the spring of 2018. For example, there are new specific record-keeping requirements, and records must be produced for supervisory authorities on demand. With respect to individual consent, consent given by data subjects must be clear, freely given, informed, and specific, and can be withdrawn at any time without consequences. The good news is that unlike the Privacy Directive, the GDPR is a regulation. The Privacy Directive, as a directive, had to be implemented by every member country in the EU into its national law, which meant that there were as many variations of the directive as member countries. Since the GDPR is a regulation, there will only be one version of it, and if in compliance with its rules, companies will be in compliance in all of the member states. What steps should companies take to prepare for the GDPR's effective date? Louis DeDroit and Thomas Markey of the firm McNees, Wallace & Nurek recommend that companies ask the following questions as they audit their data operations. 1. What personal data does my company collect and store, and how is it used? 2. Do our activities fall within the scope of the GDPR? 3. Do we meet the definition of a data processor or a data controller? 4. Do we have high-level employee responsibility for data security? And 5, have we developed a data breach response plan? These are good questions for any company engaged in data management and processing. For companies using analytics and artificial intelligence, there are some pronounced issues based on the nature of the big data and the sheer volume and variety. Companies can't assume that tools like anonymization of data will suffice. The EU will require that in that case, there's a thorough assessment of any risk of re-identification. Also, privacy by design, an approach we've been talking about since Mod 2, must be considered. Under the GDPR, it is called data protection by design or by default. And according to some authorities, it will become a legal requirement. In our next video, I will highlight summary challenges of adapting data analytics and artificial intelligence to the GDPR. In this presentation, we're going to be talking about the unique relationship between the GDPR and its requirements and data analytics and artificial intelligence. Because of the nature of the technology, there are 9 data protection principles that are threatened by its use. The first one, big data analytics must be fair. The GDPR requires fairness. We know that there can be instances in analytics and in artificial intelligence, like predictive analytics, that there can be some bias or discrimination that we're working to eradicate, but we acknowledge that it can exist. Big data analytics are required to be fair under the GDPR, so this is going to be a tension right out of the gate. Number 2, you need permission to process data under the GDPR, and it has to be unambiguous. So consent is very important. It has to be clear, affirmative. It can be taken back at any time. There are points in the process with analytics and artificial intelligence where you can't just continuously be asking for consent. So, business people are already, they've got their eyes on this requirement, considering like how are we going to have a just-in-time notification process when there are downstream uses of the data. Number 3, purpose limitation. The GDPR requires that you collect and use data for very specific purposes and that you don't use the data inconsistently with that purpose. Again, the technology of analytics and artificial intelligence makes this almost impossible because it's expected that the data might be used for other purposes than what it was originally collected for. Number 4, holding on to data. Under the GDPR and also the earlier Privacy Directive, there's an objective of keeping the data in a minimalistic space, meaning you take what you need, you only have what you need, you minimize the data, which again, based on the technology of artificial intelligence and analytics, we're actually seeking more data. We're not seeking to minimize data, we're actually looking for more. Number 5 is accuracy. We know that when data sets are large, inaccurate data might be passed over or dismissed, and also that big data might not represent a general population. We talked about this in Mod 2 when we were introducing concepts of inclusion and exclusion and Kate Crawford's work in this area. Again, not entirely possible to promise exact accuracy, working towards that, but the GDPR requires it. Next year when it comes into force, it's going to require this as one of its central principles. Number 6, individual rights and access to data. The GDPR requires that individuals are allowed to access their personal data and actually correct it if it's not correct. Again, the technology here in analytics, this is something that is not considered, or it is certainly not a practice, but we're going to have to make some accommodations here. Number 7, security measures and risk. Security is very important under the GDPR. We know that large data sets and the nature of big data processing can throw up specific information security risks that are going to have to be addressed in the European Union. Number 8, accountability. There are provisions promoting accountability in the GDPR. And again, mostly in Mod 2, when we were introducing some of the problems with algorithmic decisions, we see that they can actually, the erroneous algorithmic decisions based on bias profiling can create these accountability issues. And finally, number 9, controllers and processes. The GDPR defines data controllers differently from data processors, but it's going to be very important for anyone in the business of artificial intelligence and analytics to really get clear on what definition they fit and what rules and regulations are going to apply to them. In this video, we're going to do IRAC exercise 3 together. And recall that the IRAC exercises are a legal analysis tool to help us move from issue identification to action. The IRAC stands for issue, rule, application, and conclusion. And we'll read through this first story together. This story is about a company A, that has a new technology using the combination of a smartphone camera and machine learning to analyze the pupil of someone suffering from a potential concussion. The use of this technology is really meant to assist coaches, soccer coaches, football coaches, basketball coaches in time to identify if a person has a concussion and or not, and if they do, to keep them off the field. If they don't, to send them back in. But of course, it has other multiple uses for anybody who might be concerned from sports or an injury that they suffered a concussion. So you can read through here what the app actually does, and then you're told that you, student, are a recent hire at Company A. Your new boss knows that you took this course in law and ethics in data analytics and artificial intelligence, and he wants or she wants your opinion about any possible legal concerns that you have for this new app on the smartphone. Now, we're going to look at this this problem outside of any known FDA regulatory approvals, because of course this would have to go through a regulatory approval process. That's not what our concern is here. We're going to be looking at other issues that we've learned about that might come up, legal concerns that might come up with respect to this new app. So the issue here, the issue arises out of the context of the story. The issue for us is whether there is a possibility that consumers using the new app to diagnose a health condition, here a concussion, will experience an invasion of privacy as a result of the collection and use of that personal medical data. That is our issue. Is there a possible legal issue with respect to privacy using an app like this? Now, the rules that are relevant here are regulatory, and the regulatory law that is immediately applicable is something called HIPAA in the U.S., the Health Insurance Portability and Accountability Act. HIPAA protects health data. Remember, in the U.S., the regulation of privacy concerns is by sector, so health data, financial data, student data, so forth. HIPAA is our law to protect health and medical data, so medical records, health data. Generally, HIPAA regulates organizations that meet 2 criteria, and they're listed here for you in this rule. First, an organization must play a certain role in the provision of health care to patients. So if you're regulated by HIPAA, you are likely an organization that is having something to do with the provision of health care to patients. If it does, and it meets that definition, it will be something called a covered entity. Also, there are business associates under HIPAA. So these are legally defined terms. You're either a covered entity providing healthcare, or you're a business associate. Business associates are those that work with covered entities. So service providers, cloud service providers, storing data, for example, could be considered a business associate. Secondly, HIPAA only applies when the organization, covered entity, or business associate handles protected health information, PHI. Therefore, to determine whether HIPAA applies to this situation, we're going to be thinking about if the organization meets these definitions of covered entity or business associate, and if it is handling PHI. Now, this is a new area, right? It's a technology. HIPAA was written before apps were being created at rapid pace. So we're going to be taking existing law, HIPAA, and applying it here in the applications piece to reach a conclusion. There is no case law in this area. We can't go just look up a case about apps and HIPAA. That's unfortunately, we don't have that luxury. So we're going to have to reason through, and this is you as the new employee of Company A, this is what you would be doing. So based on what you know about this new app, how it works, who will be using it, do you think that the government regulators would conclude that your new company is subject to HIPAA's privacy and security compliance rules? So that's really the most important thing here. If we think that we're subject to HIPAA, then we have to make sure that in our business of marketing and distributing this app and taking data and managing data, that we're following along with all of HIPAA's various rules. So questions to consider here. These come from the U.S. Department of Health and Human Services, and these are suggestions about how companies in technology might consider HIPAA and think about whether or not they should be complying with the compliance rules. One, who are the app's customers? Two, who directs use of the health data? Three, does company A have a formal relationship with a covered entity, like a healthcare provider? And four, will a covered entity require the use of the app? So these are all things that help us tease through and think about whether or not this new technology should be regulated by existing law and HIPAA. And the thinking, the general thinking right now about this is that the apps, there are a lot of apps in the area of healthcare, just keeping data, managing data, and there's a lot of power that consumers can have with respect to their health data because they have access to their own information. They know where to share it, who they want to share it with. It seems like in the app area, at least, and presently, that unless the app developer is working with a covered entity like a doctor's office or a health insurance plan, it's likely that the app is going to fall outside of the regulation of HIPAA. So the distance from being a covered entity or a business associate is really important. And also because consumers can really direct the use of the data, that seems to lead the U.S. HHS to conclude that apps like this are not going to be subject to regulation, at least not now. Again, remember, we're looking in this course at existing law to see if it applies to new technology, but we're also aware that the law may and at some point likely will catch up to the technology. So at the moment, although there are certainly other regulations that could apply to the design of the app, the regulation of HIPAA, the privacy and security regulations, likely do not apply to the situation, and Company A does not have to be concerned with those.